Yes, please.
May I please, Your Worship?
Yes.
With the consent of other side, my lord, I beg to mention item number 28, my lord.
Item number 28.
My lord. May be taken up, my lord, after a week, my lord.
Okay. On the prayer of Mr. R. Sharma, learned counsel for the petitioner, made with the consent of the other side, admission hearing of this matter stands adjourned for 2 weeks. List this case accordingly.
May it please, Your Lordship. I beg to mention one WPC, my lord, regarding VRS benefit, my lord. My lord, the urgency is that the matter is pending since long, but urgency is that the company, the petitioners who were ex-employees of the company, that company will no longer exist after April, my lord. Therefore, may I pray for listing the matter on 28, my lord?
No, this week it will not be possible.
My lord.
You should have come earlier.
My lord,
Why it will not exist?
my lord, actually, it was under AIDC, my lord. The board of directors has already been decided that the board will no longer exist.
You take it next week, not this week. We'll see what can be done.
My lord, actually, earlier I have approved.
No,
Then-
next week.
Yes, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 12, Lordship,
Hmm.
that the engaged counsel Brigadier is not well today, my lord.
Item 12.
Yes, my lord, Musa.
This matter stands passed over on the request of learned counsel for the petitioner.
Obliged.
May I please, I beg to mention for listing a
Passed over
matter
for the day.
next week, any day,
What listing or what?
my lord, for admission, my lord. Because matter is pending for promotion, my lord.
Yes. So what we do is only those matters which are mentioned will now be listed. So tomorrow everybody will come for
My
a,
lord, we are waiting for last 3-4 months. It is not coming up in list. That is when.
do it. Let's put the system out of gear.
Please,
What
Your
is the
Lordship.
problem?
Lordship, I beg to mention 43 in Delhi legislature. Concern of the other side, Lordship. Matter with the cause about for the day, Lordship. My senior MD Sudhuri is not well, Lordship.
On the prayer of learned counsel for the petitioner, this matter stands passed over for the day. Yes. Yes, please.
May I please, Lordship? I praying for mention of listing of 2 matters, Lordship, for motion. Day after tomorrow, Lordship.
What is the matter?
Lordship, regarding recruitment in the CAPF, Lordship.
Sorry?
By the SSC, Lordship, regarding recruitment by the SSC, they were not selected. The day after tomorrow, it is earlier listed on 29.3, but after that not listed, Lordship.
May I please, Your Lordship? Lordship, I beg to mention for item number 41. Lordship, I'm on behalf of Jyotimar Roy, Mr. Jyotimar Roy. Lordship, may not like to taken up this matter today.
We are for the petitioner, Lordship.
Just this case before any other bench without me. Back at my name. Yes.
We are for the petitioner in this case.
Deeply obliged.
Yes.
May I please, Your Lords?
You want to withdraw?
I would do with liberty, my lordship. Earlier, 2 petitioners already filed another case, which has already disposed of. So I have filed a fresh petition only for 2 petitioners.
Liberty part, Lordship.
Huh?
Liberty part, we have objection, Lordship.
You have objection. Then we can't, we'll have to hear it. He has objection on the liberty.
No, my lordship, I am totally unknown about the fact. That's why I would do the matter and file the fresh one, only 2 petitioners. Already 2 petitioners already earlier filed, already disposed of.
You have to now file an application for withdrawal, which will be contested by him. He is opposing. You don't understand the significance.
You can file a petition for striking out. 2 of them has got the relief in another writ petition that he has not disclosed in this petition.
No, I am totally unknown, my lordship.
Then you file an application. He has objection. Mr.
N. Islam, my lord.
N. Islam, Learned Counsel for the petitioner seeks leave of this court to withdraw this writ petition with liberty to file a petition after deleting the name of some of the petitioners who have already got relief in another proceeding. However, Mr. B. Chakraborty, Learned CGC, appearing for the respondents, have objected to the prayer for granting liberty. If that be so, the writ petition cannot be allowed to be withdrawn with liberty without examining the issue raised by the Learned CGC, full stop. As such, by granting leave to the petitioner to file appropriate application seeking leave to withdraw this writ petition, this matter stands adjourned for 2 weeks. You have to now file an application and he will file his objection, we'll decide. He'll file his objection, then we'll decide what is the issue. It is contested, you can't help it.
Wait, Richard Lordship. In this case, the petitioner before Lordship, the Anganwadi helper, my lord. She was seeking promotion to the post of my lord Anganwadi worker.
That advertisement is already stated by your lordship, and we have received the instructions that apart from that engagement letter, which my learned friend has annexed, there is no any other record in the department. Lordship,
Then we have to decide.
already it is state lordship, lordship may fix after some 2 or 3 weeks lordship. In the meantime, if I can gather something lordship.
Heard Mr. Ayat Saikal and counsel for the petitioner, parents the order dated 12/4/2023, which goes to show that there is no record of engagement of the petitioner as
Except that engagement letter lordship.
As Anganwadi helper, except the solitary letter annexed to the petition. Mr. H. Sharma, learned additional senior government advocate, Assam, prays for 3 weeks' time to obtain instruction and file affidavit. Prayer allowed, NOM, 3 weeks. Returnable, notice of motion returnable in 3 weeks. Since Mr. Sharma has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned standing council, learned government advocate Assam. So as to enable him to obtain instruction, file affidavit. Interim order passed earlier to continue until further orders.
May it please your lordship. Lordship, some instructions was called for. Your lordship.
Instruction received. Kindly allow 2 times file affidavit. I will file affidavit, my lord.
What is the matter about?
Lordship, the petitioners were serving as grade 3 and grade 4 employee under Bishnee Municipal Board. And they were suddenly one inquiry was conducted regarding 10 of the employees, and the petitioners, including the 10 of the employees, were thrown out without following any process of law or any show cause notice or anything, stating that their regularization was illegal. However, the report, the inquiry report, which is also annexed herewith, says that they were appointed against regular vacant posts. However, the impugned order says that their regularization was illegal.
So
Yes, I will file.
let him file. You are appearing for whom?
BTC.
Heard Mr. Divya Mukherjee, learned counsel for the which petitioner is also heard Mr. M.
RK Musa.
R.K. Mushari, learned standing counsel BTC, appearing for the respond numbers.
For the respondent.
All the respondents.
No, 1, 2, 3.
1, 2,
Chairman and executive. Sir.
huh?
1, 2, 3.
1, 2, 3.
Hmm.
Who submits that he has received instruction in the matter and therefore be granted 2 weeks time to file affidavit. Since the services of the petitioners have been terminated allegedly without following the due process of law, this matter would require adjudication based on the affidavit filed by the respondents. As such, issue notice of motion returnable on 24th of May 2023. Since the respond numbers 1, 2, and 3 are already represented, no formal notice is required to be sent to said respondents. Extra copy of the petition be furnished to Mr. Mushahari within 2 days from today. Petitioner to take steps for service of notice upon respond numbers 4 and 5 by registered post with AD within 3 days from today. And the affidavit on behalf of respond numbers 1, 2, and 3 to be positively brought on record on or before 22nd of May 2023 by serving advance copy upon the petitioner's counsel. List this case again on 24/5/2023.
May I pray for an interim relief, your lordship?
What is the interim relief?
At least the post, 3 posts may be kept vacant if they are going for a fresh.
Now, are they filling up the post? Any
We are
action?
No,
contemplating.
no,
your
not
lordship.
filling. Not filling in.
No, why? On what basis?
Lordship,
They can't do it. This is sub judice matter.
May I please your lordship?
Hmm.
Lordship, today instruction sought for lordship, whether statutory appeal has been filed or not. Petitioner before your lordship is the son of the ex Gaon Pradhan lordship. Basically, we are challenging the selection and appointment of the Gaonbura lordship in this case lordship. And we have filed the statutory appeal before the North Assam Commissioner lordship, but till today, we have not given any number or any process has not been issued.
May I pray lordship 1 week timeline so that we have not yet received lordship.
All right, heard Mr. R. Borwal and counsel for the petitioner peruse the order dated 11/4/2023. Mr. H.K. Sharma, learned additional senior government advocates. Assam submits that instructions as called for has not yet been received. And therefore, further 1 week's time be granted for obtaining instruction. Prayer allowed. This case again after a week for motion. Let us see what happens.
Deeply obliged.
Lordship, kindly after timing, Lordship, kindly matter will be taken up for some time.
Let us see what is the matter. What is
May
the
I please
matter?
the Lord,
Yes.
my lord. There are 3 petitioners before the lawsuits, my lord.
Hmm.
2 of them have already retired and the third is subject to be, is recently going to retire, my lord. They are the employees of the irrigation department
Yes.
and formerly in the year 2005 only they came from a corporation which was under the irrigation department. And I beg to draw your lordship attention to page 33.
Hmm.
In the year 2005, by a notification, my lord, in pursuance of the MOU held on so and so between the Government of Assam and the Ministry of Finance, Government of India, conveyed by Finance Department, letter number so and so, as per the approval of the cabinet dated so and so, and following 260 numbers of employees of the cadre of ASMIDC Limited are hereby absorbed against the analogous vacant post of the irrigation department with immediate effect so and so. So there are some conditions, their services were protected, past services were protected, my lord. And they have been continuing their service. In the year, then again, my lord, in the year 2016, by notification annexure 6, my lord, page 70, annexure 5 may kindly be seen, my lord, your lordships. This is the vital here. In pursuance of the Honorable Guwahati High Court's common order dated so and so, passing WBC number so and so, the Governor of Assam is pleased to count the past services of 260 numbers of employees of the erstwhile Assam State Minor Irrigation Development Corporation absorbed against the sanctioned vacant post under the Irrigation Department by notification number so and so, or allowing them pension and other pensionary benefits only in relaxation of the Rule 31 of the Assam Services Pension Rules 1969, subject to the condition that the GOP share of CPC benefits already availed by the state employees shall have to be refunded to the state exchequer in terms of the Rule 23 read with note 1 of the Pension Rules 1969. This is issued with the concurrence of the Finance Department by number so and so and pension of public departments with the joint. Now what happened, my lord? These people, these present 3 persons are the members of the 260 number of persons who were initially of the corporation and subsequently marched to the government of Assam. They come long, they rendered their service about 32, 33, 34 years of service, and they are pension paper now.
So there are some move to some refund.
No, not question, my lord. Now, it is a question of a refund, my lord. When their pension paper has been submitted to the AG, the AG put a question, my lord, annexure 7, page 7.
All the petitioners have retired. All the
two-
petitioners
two
have
peti-
retired.
two of them have retired and third is going to retire. Pension paper submitted. to
You
the
wait, you wait till he retires, otherwise this petition is not maintainable.
No, my lord, two have already retired. Their pension paper have been submitted. Now AG put a question to the government whether they are entitled to the benefits provided under the MSCP. MSCP, my lord. So in here, I beg to draw your lord's attention to page MSCP notification para. Page 71, my lord. Page 71 in the MSCP notification. And page 72, my lord. Page 72, your lordship para 10. Page 72, para 10, my lord. The past service rendered in public sector undertaking under any other state public sector undertaking, autonomous body, state level public enterprise, or any other statutory body shall not be counted for the purpose of MSCP. But facts remain, my lord, these three persons and some others, they were already paid the MSCP benefits because there was no promotional benefit. They could not avail any promotion. Now, our question before the lawsuit, my lord, and before the government, my lord, these people are to be exempted from these provisions because in view of this circular, I have drawn your lordship attention, page 70 notification, and yes, it is true that they were employees of the corporation, but their case is exempted because of this, page 70, and also first notification of the year 2005. Page 33. With the cabinet decision, with the finance concurrence, even in the Annexure 5, Annexure 1, my lord, the Ministry of Finance of Government of India is also there, mentioned there, my lord. After all,
So are you challenging the notification dated 18/11/2026, 2016, or are you seeking its implementation?
No, my lord, we are not. What notification, my lord?
What notification? Page 70.
70, my lord. We are not challenging this one, my lord. We are in support of this one. Our service is protected by this notification. Now, the government has put a question, if the MSCP benefits cannot be given to us, should it be given to us? The government, AG put a question to the government, and government replied, no, they are not entitled. But our case is, my lord, since our service were taken by these two notifications, and it is 262 persons of the erstwhile corporation taken to the irrigation department, protecting the all benefits, service benefits. So their case to be exempted from the para 10.
So the retired employees are also expecting MSCP benefits.
No, my lord.
Then?
They have already availed.
Right. So I'm asking you, is there any move to refund?
By virtue of the circular notice of the government, it appears that the fund is required, my lord. Impugn order, my lord, at page 76.
It appears will not do. Is there any steps to?
They have not yet taken any steps.
Then why have you filed this petition?
My lord, AG put a question whether it is to be done so in this way. Then the government replied, in inviting reference to the subject cited above, I am directed to inform you that as per Finance Department notification number dated so-and-so 17, the past services under the public sector undertaking under any other state public sector undertaking, autonomous body, state level public sector enterprise, or any other statutory body shall not be counted for the purpose of
Mr. Gogoi, what is the matter?
Here, the issue of the petitioner is this, my lord. Against a query raised by the AG, the petitioner is agreed by that, my lord, whether they will be entitled for the MSCP scheme or not, my lord.
No, but
They
two of them
already
have
retired, my lord.
retired.
They already retired, they avail, my lord. And if there is a query, let the authority, my lord, look into that, my lord, instead of, my lord,
Only
approaching this.
because there is a
court.
query, come to the court.
Yes, my lord.
No, my lord, the AG put a question, then the
So-
government gave a reply. We are challenging for Annexure 8A, my lord, page 76. The Undersecretary to the Irrigation Department submitted reply to the AG.
Lordship will see, my lord, that letter, it only says that, my lord, the past services will not be counted. That is there already, my lord.
But I am not understanding.
How they
Those
agree?
who have retired already, where is the question of granting them a MSCP benefit
Yes,
now?
and there is no order for recovery.
They have already availed my,
Right.
now because of this letter, it appears that it will be,
Oh, it appears
Deduct
to you. It appears it is your opinion. We are not concerned with that. Your opinion will not give rise to a cause of action. Appears means what appears? Is there any move to withdraw any amount from you? And even if there is a move,
no,
will not
no such
entertain this.
move has yet been done. my
That
lord.
will come when there is a cause of action. And in any case, the law regarding retired employees and serving employees are completely different. So this writ petition with some petitioners retired, some serving on this court will in any case not be entertained by this court. So even if there was a move to recover, then also I would not have entertained this.
My lord, because this is letter of the government given to the
I understood.
AG, the AG will be deducting, my lord.
What AG will be deducting? How can AG deduct?
No, my lord, because the government has given the reply, they are not entitled.
Let the issue come, then we'll see. We cannot preempt action like this. Let this stage come when there is a move to deduct. What will be deducted, from whom it will be
Yes.
deducted, under what, all these things we don't know at this stage. How can?
And there will be an order for the in that regard, my lord. That they can challenge, my lord, if such an order is passed.
Why have you come now?
Because we are apprehending because of this letter, because of the letter
I
of this.
heard Mr. M.H. Rajbarbui, Learned Counsel for the petitioner. I also heard Mr. B. Gogoi, Learned Standing Counsel, Finance Department, Assam, Ms. D. Nyog, Learned SC Irrigation Department, Assam, as well as Mr. R.K. Talukdar, Learned Standing Counsel, Office of the AG, Assam, appearing for the respondents. In the wake of the communication dated 6/6/2022, bracket annexure 8, bracket small a, bracket close, issued by the Undersecretary to the Government of Assam, Irrigation Department, dispute addressed to the respondent number six. This writ petition has been filed by 3 petitioners, apprehending that there will be some deduction of the MSCP benefits already paid to them. However, the fact remains that no such steps for refund or deduction of MSCP benefit given to the petitioners has been initiated as on date. Moreover, out of the 3 petitioners, 2 have already retired from service, and therefore the question of denying them any future MSCP benefit also does not arise at this stage. Under the circumstances, this court is of the opinion that this writ petition is premature. First up, on such ground, the writ petition stands disposed of as premature by granting liberty to the petitioners to approach this court as and when a proper cause of action arises. We come when a proper cause of action arises. This is not this stage.
Item 6.
Where petition, here rule has been challenged, my lord. I think to go to the
What rule?
division,
Which rule?
that is post title your lordship will find in the page 3, my lord. Legality and welfare rule 6(6)B of the Assam Ministerial Establishment Service of 1967 in respect of grade 4 employees. What happened, my lord?
It has to go to division bench.
Yes,
I heard
there's a-
Mr. B. Sinha, Learned Counsel for the petitioner, who submits that in this writ petition, rule 6, bracket 6, bracket close, bracket small b, bracket close of the Assam Ministerial District Establishment Service Rules 1967 is under challenge, and therefore this matter would lie before the division bench. Mr. G.J. Bordole, Learned Standing Counsel, Cooperation Department, Assam, has also agreed to the said submission. In view of the above, register to verify and list this matter before the appropriate bench.
Item 7.
Make legal. Lordship, we applied for a post of Gaon Pradhan, Lordship. Thereafter, Lordship, the participating candidates, we are for Lusanbari. At page 22, Lordship would see, had given a letter to the MLA. In turn, this letter was given to the Chief Minister. Lordship,
Yes.
for recommending the candidates. I have the honor to state that the office of the Deputy Commissioner Morrigan DC have published an advertisement inviting application for the
Which
post of
page you are
ground
reading? Which page?
22. Gaon Pradhan is lying vacant in this year since there is no MLA of our party in Batodraba and Lahori. The workers of Bharatiya Janata Party has made a prayer to make arrangement for appointing the candidate selected by them. The said list is being forwarded herewith for your approval. I request your good self for approval of the list. Therefore, this is the list. The Lordship would see at page 24 is the vernacular where the signatures are there. Thereafter on 6/4, this is the list. We are concerned with serial number 10 at page 25. Ataur Roman. Thereafter, this list was forwarded. Now at 6/4, the 66 posts have been filled up. All the 10 candidates, including Ataur Roman, is selected, Lordship. Secondly, there are complaints. Lordship, there are consideration for appointment of Gaon Buddha is 3, Lordship. One is the wishes of the villagers and the precedence to the family, and other is the views of the Modadar. Lordship, these are the relevant consideration. This is not a relevant consideration to be taken, Lordship. So there is a clear non-application of mine. Secondly, Lahori Ghat, Lordship, is a outlying subdivision where the competent authority is the SDO. Who is the competent authority to appoint? Here the DC has appointed. He is not the competent authority.
Where is the select list?
Select list, Lordship would find at page 36 is the order. At page 34 is the English version, Lordship. May I read? On the basis of the notice, notification dated 7/7 for filling up the post of Gaon Pradhan, interviews are held for the last 13/12/2022 as per decision of the selection committee. On the basis of eligibility for the post of Gaon Pradhan for the below 66 number of persons are declared as selected for the post of Gaon Pradhan. Now, Lordship, this is the list village circle onwards, Lordship, Lahori Ghat Revenue Circle at page 37. 38 is the translated. Copy, Lordship, but at page 35, Lordship, we have extracted the necessary part of Ataur Roman. As per the scheme of the act, also the DC is not the competent authority. This is outlying division. 162.
Yes. What do you have to say, Mr.
Lordship,
Chakravarti?
petitioners are not been selected, Lord, not selected, Lordship. That's why, Lordship. And on there is a provision, Lordship, in subsection 5 of this
No, but,
executive instruction,
this was
Lordship.
done some recommendation.
Lordship, that's what obtained instruction, Lordship, regarding this, Lordship.
Appointment order has been issued in favor of respondent.
No,
No.
till now not.
No,
Yesterday
only
also we have,
selection was done, Lordship.
we have also inquired, Lordship. Till now appointments has not been.
All right, heard Mr. BP Boral and counsel for the petitioner also heard Mr. H. Chakravarti, learned government advocate Assam appearing for the respondent numbers
2 and
1,
3,
2 and 3. Mr. S. Datta, on his standing counsel, Revenue Department Assam has appeared for respondent number 1. By filing this petition, the petitioner has challenged the selection of respondent number 4 for appointment as Gaon Pradhan for the village Lachanbari Boholmukh under Lahori Ghat Circle of District Morrigaon. Full stop. By referring to the materials available on record, Mr. Bora submits that the selection of the respondent number 4 is based on extraneous consideration, and the selection process has also been conducted by the respondent number 2, who was not competent to issue the notification of selected candidates
Under 162A of executive instruction.
under 162A of the executive instructions framed under the Assam Land and Revenue Regulation, since Lahori Ghat
Is an outlying subdivision.
is an outlying subdivision of the Morrigaon district. Full stop. Upon perusal of the materials available on record, it appears that the petitioner has made out a strong prima facie case. First up, Mr. Datta and Mr. Chakravarti, learned departmental counsel, have prayed for some time to obtain instruction in the matter. First up, in view of the above, issue notice of motion returnable on 29th of May 2023. Since the respondent numbers 1, 2, and 3 are already represented, no formal notice is required to be sent to said respondent. Extra copies of the petition be furnished to the learned department counsel so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 4 by registered post with AD within 3 days from today. The learned government advocate Assam to also produce the records pertaining to the selection process involved in this proceeding. Full stop. Heard on the prayer of interim relief. As an ad interim measure, it is hereby provided that no order of appointment shall be issued in favor of the respondent number 4 till the returnable date. Order of appointment as Gao Pradhan shall be.
May I please, your lordship? What has happened here, your lordship? The petitioner, your lordship, earlier, your lordship, a disciplinary proceeding was initiated against him, your lordship. He challenged that disciplinary proceeding, your lordship. Enter disciplinary proceeding, your lordship. And if your lordship comes to page 86, your lordship, of my petition. Initially, there was no stay, your lordship. Disciplinary proceeding continued during the pendency of the earlier writ petition, your lordship. Writ petition number 8004 of 2019. Then your lordship on in page 85, your lordship. Lordship,
So
now
removal from service.
removal from service, your lordship, but I have challenged the, your lordship, the initiation of the disciplinary proceeding itself, your lordship, in WPC 8004 of 2019, your lordship. In that case, your lordship, there was an order by this honorable court, your lordship. That is at page, starts from page 85, and if your lordship comes to page 87, your lordship.
Yes.
Last paragraph, indeed, that this matter needs further consideration. However, if in the meantime any penalty is imposed upon the petitioner on the basis of departmental proceeding, the same may lead to multiplicity of litigation. In that view of the matter, though the respondents are permitted to proceed with the departmental proceeding against the petitioner. However, the respondents are restrained from imposing any penalty upon the petitioner till the next date of hearing, list the matter on so and so for hearing. Next page, your lordship, matter came. However, somehow your lordship interim order was not continued. And in the meantime, they passed this order, your lordship. Now, my prayer is this, your lordship, since I have already challenged the initiation of disciplinary proceeding itself, your lordship, and it is in the hearing column, your lordship, this matter may be, your lordship, tagged along with that. I have filed this, your lordship, so that your lordship, no prejudice is caused to me, your lordship, by not challenging.
I had Mr. S. Bothakul and counsel for the petitioner assailing the order of major penalty. Assailing the order dated 10th of March.
Lordship.
10th of March 2023, imposing the major penalty of removal from service upon the petitioner. This petition has been filed. Mr. Bothakur submits that a connected writ petition being WPC number 8004/2019, whereby the very initiation of the departmental proceeding is under challenge, is pending disposal before this court, and therefore both these matters be taken up together for final hearing and disposal. Mr. B.P. Bora, learned standing counsel, Health and Family Welfare Department, is present and prays for some time to obtain instruction in the matter. In view of the above, issue notice of motion returnable in 4 weeks, since Mr. Bora has appeared and accepted notice on behalf of all the respondents.
Yes,
All the
my lord,
respondents.
all the
No
respondents.
formal
All
notice is required in this case. Extra copies of the writ petition be furnished to the learned department counsel. Let this writ petition be tagged along with WPC number 8004 of 2019.
Please, lordship.
It's regarding compassionate appointment, my lord. A case was not considered, my lord, but not properly. Therefore, this honorable court directed, my lord, of fresh consideration. Thereafter, my lord, it's been rejected on the ground.
Compassionate appointment, when did the,
Died in 2006, my lord. But then thereafter, this matter was kept pending for long. Then she approached this honorable court, directed fresh consideration because our case was not considered against grade 4 post, my lord, to comment with commensurate with the qualification, my lord. Thereafter, my lord, it's been
but
freshly
what do you have to say on this, that today a writ of mandamus cannot be issued
my lord.
to appoint the petitioner on compassionate ground?
Right.
That will be divorce the scheme, the settled law, the declarations, because after the time has elapsed.
Well, that's true, my lord. But then the fact remains, well, this has been kept pending by the department, my lord. It was their fault, my lord.
We
Otherwise,
will issue notice and club all
I
cases
understand, my
together,
lord.
so that we'll dismiss all the cases by a common order. It can't be done. This can't be a business. Compassionate appointment was a very sacrosanct idea
It's true, my lord.
to give immediate relief to the family member.
But the way the authorities are dealing with this matters, well, that's well, another matter of
But
concern.
it should have been brought to the notice of the court earlier.
Well, she was not communicated any reason, my lord. Therefore, when she was communicated, she came to the honorable court, my lord.
That's correct. But then since 2006, we are almost, this is 17 years.
My lord.
She has been waiting for 17 years.
No, but she came in between, my lord. There's a duration.
Came in between means when?
My lord, that is, my lord, at page 40, my lord, 45, my lord, there is a writ petition in, my lord, 2017.
She came in between. That is also after more than
That's
11 years.
She was not communicating any reason, my lord, that our case was rejected, my lord.
I don't know what order was passed on 3/11/2007. What was the order passed?
My lord, the order was passed first, my lord, for taking my lord, considering a case, my lord. My lord, against all, my lord.
That's the point. How
Probably
could the
postman.
case be considered after 11 years?
Because, my lord, when it was considered, my lord, she was, my lord, they were called for an interview, my lord, they were called for, my lord, the constable's post, my lord. She was found to be physically unfit, my lord. And, my lord, but then the compassion appointment has to be, my lord, against all spectrum of post, my lord, all kinds of post, my lord. It cannot be a post-based, my lord.
Yes, what do you have to say, Mr. Bora?
Your lordship, only on a ground of delay only.
Argo will decide the case today.
Your lordship, because the petitioner's husband, she died on 26/5/2006. Now, the basic motive of any compassionate appointment case is basically giving immediate relief.
So where are the laws? Where are the decisions?
Your lordship, I am not ready with the
Heard
laws.
Mr. M. Dattal, counsel for the writ petitioner. The father of the petitioner died in the year 2000, died in harness. Husband of the petitioner died in harness in the year 2006. Whereafter the petitioner had submitted an application seeking appointment on compassionate ground. However, the application of the petitioner was not considered by the DLC, as a result of which she had earlier approached this court by filing WPC number 6616 of 2017, which was disposed of by the order dated 3/11/2017 with a direction upon the respondents, with a direction upon the DLC to consider the case of the petitioner. Full stop. Even thereafter, the DLC had not recommended the case of the petitioner.
No, he didn't recommend it. SLC rejected, DLC recommended.
Thereafter, the DLC recommended the case of the petitioner for appointment in a grade 4 post, but the SLC had rejected her application on the ground that what is the ground?
Ground where application was delayed, madam. The
On the
application was
ground
delayed.
that the application itself was delayed. Full stop. When did you file the application?
My lord, within 1 year, my lord, that lordship will find the application is there, my lord, next day. On 7, my lord, just forwarded. Page 24, my lord.
Hence this writ petition. Mr. D. Bora, learned government advocate Assam submits that the prayer of the petitioner is barred by time, but he is not prepared to argue the matter on merit today. Full stop. On the contrary, Mr. Bora prays for some time to seek instruction in the matter. As such, NOM 6 weeks. Since Mr. D. Bora, learned government advocate Assam has appeared and accepted notice on behalf of all the respondents, no formal notice extra.
Keep it up, my lord.
Pursuant to my lord, the judgment of the Honorable Court in Upendas, my lord, a committee was constituted in the Finance Department to scrutinize a list of work charge employees, master role, and casual workers who had spent more than 10 years continuously, my lord. Our name was recommended, my lord, which your lordship will find at page number 89, my lord. If your lordship kindly turns to page number 89 for a moment, my lord. Your lordship will see,
89 or 59?
89, my lord. 89. Page number 89, my lord. May I just read out?
Yes. Yes.
My lord, it is from the additional secretary to the Government of Assam Environment and Forest Department to the Principal Chief Conservator of Forest, my lord. Payment of minimum pay wage to the master role work charge casual and similarly placed workers who were appointed prior to FRMB oblique post FRMB period in pursuance of the Honorable Code dated 8/6/2017 passed in Writ number 45 of 2014. It says, my lord, sir, with reference to the subject cited above, I am directed to enclose here with list of 697 numbers of master role work charge casual and similarly placed workers who were appointed pre-oblique post AFRMBM period pertaining to Forest Department, both general area, 533 numbers of casual workers, and BTC area, 164 numbers of casual workers and work charge employees as approved by Finance Department by letter number so and so, my lord, dated 16/9/2021. You are requested to strictly follow the guidelines of the Finance Department contained in the aforementioned letter and take necessary action for extending the benefits of the payment of the minimum pay scale to the master role work charge casual and similarly placed workers in the pursuance of the Honorable Court order dated 8/6/2007 passed in Writ 45 of 2014. Now, below, my lord, enclosed, your lordship will see, my lord, as stated above, list of 533 numbers of workers approved and duly authenticated by the Finance Department. But despite the approval and the authentication of the Finance Department, my lord, till date those benefits of the judgment of the Upendas have not percolated to the people from general area.
Heard Mr. A.K. Borwal and counsel for the writ petitioners. According to the case, as per the case projected in the writ petition, the petitioners herein numbering about how many?
111, my lord, in total.
111 claim to have been working under the Environment and Forest Department, Assam, as master role workers, stroke work charge employees, stroke casual workers, stroke temporary employees for a period exceeding 10 years in continuous service. First up, as per the judgment of this court rendered in the case of State of Assam and Upendas and others, in writ appeal number 45 of 2014, the petitioners were entitled for consideration of their case for regularization.
For minimum pay scale, my
For
lord.
minimum pay scale. However, according to the petitioners' counsel, although their names featured in the list
Duly
of
authenticated and, my lord, approved by the Finance Department.
authenticated list of beneficiaries as approved by the Finance Department, no steps have been taken to extend in the benefit of minimum pay scale as per the judgment of this court. Hence this writ petition. First up, Miss, your name, please. Yes.
M. Kalita, your lordship,
Miss M. Kalita, learned counsel,
for the Forest Department.
learned standing counsel, what?
For respondents 1, 2, 3, and 4.
Forest Department, Assam, appearing for respondent numbers 1, 2, 3, and 4. And Mr. H. Aliya, learned standing counsel, Finance Department, Assam, appearing for the respondent number 5, have prayed for some time to seek instruction and file affidavit. Prayer allowed NOM 6 weeks since the respondents are already represented. No formal notice. Extra copies be furnished to the learned departmental counsel so as to enable them to obtain instruction and file affidavit facilitating disposal of the writ petition at this stage of admission hearing.
Deeply obliged. Deeply obliged.
May I please, your lordship? My lord, in this case, the claim of the petitioner for appointment on compassionate ground has been rejected on the ground that the, my lord, deceased government servant has less than 3 years of service, my lord.
That is now reversed.
Yes, my lord. That's
Subsequently reversed. Your
reversed,
lordship.
my lord.
Initially, it was his case
But
was
what has happened? The 30th of June, what is the judgment?
Yes, my lord.
Zero
Judgment dated, my lord.
30th of January.
23rd of January.
30th of January.
Lordship. An
30th.
appeal,
30th January.
So any appeal has been preferred against it?
appeal has been filed, your lordship. It has not been numbered because of there's a bit of.
Right, then we'll issue notice. I heard Mr. B.P. Boyan, I counsel for the petitioner. The grievance of the writ petitioner is that his application for appointment of on compassionate ground was rejected by the authorities merely on the ground that the deceased government servant had less than 3 years of service to his credit at the time of his demise. First up, by referring to the recent judgment of this court dated 30/1/2023, rendered in WPC number 1646 of 2021, wherein clause 1 of the OM dated 1/6/2015 have been held to be unconstitutional. Mr. Bora submits that the case of the petitioner would consider would merit reconsideration, would warrant reconsideration in the light of the aforesaid judgment of this court. First of Mr. C.S. Hazarika, learned government advocate Assam, appearing for the state, submits that although an appeal has been preferred against the judgment and order dated 30/1/2023, yet the appeal has not yet been listed before the court. Under the circumstances, this court is left with no option but to examine the issue raised in the writ petition. Full stop. NOM 6 weeks since Mr. Hazarika has appeared and accepted notice for the
4 and 5, Your Honor.
4 and 5 and Miss
Kotoki
Kotoki
for 1, 2, 3 and 6.
correspond numbers 1, 2, 3 and 6 service of notice is deemed to be completed with extra copies, etc. etc.
My lord, item number 15 similar, my lord.
15 similar. Same area of parties also. Same. Same order and then list along with
Obliged,
item
my lord.
11.
Item 13.
May I please your lordship?
Yes.
Lordship, the petitioner is a master roll labor lordship, and he is entitled to work till 60 years in terms of Upendas's judgment. Now, lordship, he is aggrieved by the release order, which is at page 40, lordship. His grievance is that he has been sought to be released prematurely. Lordship may kindly come to page 40, lordship.
Yes.
As per record available and this office letter number so-and-so dated 5/12/98, you have attained on the age of 60 years on 31/1/23. Accordingly, you are hereby released from government duty with effect from 31/1/23. This has been issued by Lordship Executive Engineer, Dhubri, Water Resource Division, Dhubri, Lordship. Now, same authority, there are other documents also, but the same authorities, ID card issued by the same authority. I will show his date of birth, Lordship. ID card, Lordship.
What is the age recorded in a service book?
Lordship, their service record are not maintained, master roll labor, Lordship.
And then in the roll, what is the date of birth?
Roll,
Lordship,
ID
in
card,
this,
Lordship.
in this case, Lordship, this is a case of forgery, Lordship. What I can say, Lordship, because in page number 18, petitioner has annexed the school certificate where his date of birth has been shown as this one, Lordship. He's as claimed by the petitioner, but the original date of birth on the same school certificate issued by the same principal on the subsequent date.
So then you will have to file affidavit.
Lordship.
Let him file affidavit.
Lordship, I will bring it now to my court.
Dr. G.J. Sharma, learned counsel appearing for the petitioner, assailing the communication dated 1/2/2023 issued by the respondent number
4, Lordship.
Number 4, releasing the petitioner from duty with effect from 31/1/2023 on attaining the age of superannuation, bracket 60 years. This writ petition has been filed inter alia contending that as per the documents available on record, the date of birth of the petitioner is, what is the date of birth?
Lordship, 27/11/1968. This is the actual date of birth.
27/11/1968. The actual date of birth of the petitioner is 27/11/1968, and therefore the impugned letter order dated 1/2/2023 has resulted in premature retirement of the petitioner. Full stop. Mr. R.M. Das, learned standing counsel, Water Resources Department, on the other hand, submits that this is a case of forgery where the petitioner has produced concocted documents so as to alter his date of retirement. First of the learned departmental counsel prays for some time to file affidavit bringing the relevant facts on record. In view of the above, NOM 6 weeks since Mr. Das has appeared and accepted notice on behalf of respondent numbers 1 to 5. No formal notice is required to be sent to the said respondents. Extra copy of the writ petition be furnished to the learned departmental counsel. Requisite in numbers so as to enable him to obtain instruction and file affidavit. Why have you implemented the executive engineer by name?
Lordship, ID card has also been issued by him, wherein my correct date of birth has been recorded, and same authority has issued a release order with different.
So does it mean you have to implement him by name? By name implement is required when you are making a personal allegation of malafide.
I have alleged malafide.
Where is it? Where is it? Let us see. Malice on fact, not malice in law. Where is the statement?
Lordship, paragraph 13, Lordship.
Paragraph 13, what does it say?
Lordship, last 3 lines, Lordship. It is stated that such incongruity in the date of birth between ID card and the release letter issued by the same authority, that is the response number 4/6, speaks of malice and malafide against the petitioner.
No, this is not malafide. It is not malice in fact. You know what is malice in law and malice in fact?
Yes,
Are you aware? Yes or no?
yes, Lordship.
What is malice in fact? And how is it different from malice in law? Legal malice and factual malice. What is the difference?
Lordship.
Huh? You just said yes. So now tell us, what is the difference? You know, there are 2 types of malice.
Yes, Lord.
One is malice in law,
Malice.
other is malice in fact.
Yes, Lord.
What is the difference between the 2?
I'm little confused, Lord.
Little confused. All right, you remove your confusion. I'll give you one more chance. After going through the pleadings in the writ petition, it appears that the implement of respondent number 6 in his personal capacity was uncalled for in this case. However, on the request of Dr. Sharma, who seeks time to satisfy this court that there is malice in fact pleaded against the respondent number 6, this matter is kept open till the next date.
Much obliged, Lord.
This issue is kept open till the next date, not matter. Yes.
Your Lordship, this is a case of punishment given to an FCI employee by the FCI management, wherein the inquiry report exonerated the employee from all the charges, imputation of all the charges, and then the regional authority, after receipt of inquiry report, they disagreed with the inquiry report, and he punished the officer. He punished the officer by reduction of salary in time scale for two increments.
So what are you challenging here?
The order of the disciplinary authority.
What is that order?
It's annexure 1.
Annexure what?
A1.
Oh, page number?
Page number 17.
The penalty order is at page 87, my lord. Page 87.
This is the order. Order of
Not charge.
Charge.
Your lordship has asked about the penalty order.
What are you challenging here, Mr. Gupta? What is the
I'm challenging the charge memo.
Charge memo?
Yeah.
But now it is concluded, it is
Yes.
needed to.
The penalty, yes.
After the penalty, you are challenging the
Yes,
charge memo.
that also I have.
Right, you can do anything. Yes, where is the order of penalty?
It's 87 page number 87.
Yes, what is the date of the order?
2/8/18.
Okay, you are challenging it after 5 years.
Your Lordship, this we have given to the senior officer, the next appellant authority. We have given representation to the appellant authority. Appellant authority passed order that he did not interfere with the order of the regional authority. Then he gave time that you can also, if you are not satisfied with the order, you can review. You file a review to the managing director. We have appealed to the managing director for review of the order in the month of March last year, but no response is there from the managing director's office. After having waited for 1 full year, we are coming to your Lordship.
What is the penalty imposed?
Penalty imposed is reduction of 2 stage in the time scale of the pay for a period of 2 years. He will earn increments of pay during the period of such reduction.
So and on minor penalty.
Minor penalty.
It's major. He was charged sheeted under major penalty clause. 58, major.
All right, we'll issue notice at this stage. Our Mr. G.K. Gupta and counsel appearing for the writ petitioner. The writ petitioner is serving as an employee of the FCI and posted as what?
AG2 at that time. Now he is AG1 at Nogam.
And posted as AG1. AG means
Assistant grade.
assistant
grade 1.
Assistant
grade
grade 1.
1 officer at the Nogam. What is this called? Nogam Depot.
Divisional office.
Divisional
Nogam Divisional Office of the FCI. Agreed by the order dated 2/8/2008. Inter alia being agreed by the order dated 2/8/2018, whereby the penalty of reduction of 2 stages in the time scale of pay for a period of 2 years was imposed upon the petitioner. The instant writ petition has been filed. According to the petitioner's counsel, the departmental proceeding itself leading to the issuance of the order of penalty is dehored the rules and therefore calls for interference by this court. Mr. V.K. Singh, learned standing counsel FCI, prays for some time to obtain instruction in the matter. Issue rule returnable in 6 weeks. Since Mr. Singh has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the Planet SCFCI so as to enable him to obtain instruction and file affidavit.
Obligement.
Definitely, Lordship. Matter pertains to compassionate appointment, Lordship. Petitioner's husband died in 2009, Lordship, and applied in December 2009. Our case is not placed before the district level committee, Lordship, still.
2009.
2009, Lordship. My humble prayer on this, Lordship, placed before the district level committee and district level
It was
committee.
never placed before the district level.
Never.
Why?
Lordship, I have to take instruction. Or Lordship will dispose of also Lordship directing the authorities to.
No.
Then Lordship, I will take the instruction, Lordship, why it is not placed. If it is not at all placed, Lordship.
When was the application filed?
24/12/2009, Lordship.
24/12/2009.
9, Lordship. Page 12.
Take down. Heard Mr. M.K. Niyam, learned counsel for the writ petitioner. The case of the petitioner in a nutshell is that after the premature death of her husband, who died on 24/10/2009 while serving as Deputy Accounts Officer in the establishment of Executive Engineer, Dhemaji Irrigation Division. The petitioner had filed an application dated 24/12/2009 seeking appointment on compassionate ground. Full stop. However, till today, her application has not been considered by the DLC of Dhemaji. Hence, this writ petition. Although this writ petition prima facie appeared to be hit by the principles of delay and laches, yet since the application was filed within time, hence this court would like to know as to why her application was never considered by the DLC. Full stop. As alleged. Full stop. Mr. N. Upadhyay, learned standing counsel, Irrigation Department, Assam, prays for 4 weeks time to obtain instruction in the matter. Prayer allowed. NOM 4 weeks. Since Mr. Upadhyay has appeared and accepted notice for respond numbers. Respond numbers, you have to tell every matter the respondents must be ready with who is appearing.
1,
for.
3 and 4, Lordship.
Otherwise, we'll pass some strict.
1,
1, 3 and
4.
1, 3 and 4 and Mr. C.S. Hazarika, learned government advocate Assam for respond number 5. As well as Mr. A. Salia, learned standing counsel finance department for respond number 2. Service of notice in this case is deemed to be complete. Extra copies will be provisionally furnished to the learned department council so as to enable them to obtain instruction facilitating disposal of the writ petition at the stage of admission.
All right.
My lord, in this case, in pursuant to this honorable court order, my lord, we publish the result, my lord, out of the 6 petitioner, 4 are get for my lord. So my lord, my submission before your lordship kindly in the last order, when your lordship passed the order that my lord not to appoint. So my lord, keeping aside those 4, my lord, other maybe, I don't know, there may be an order to pass the appoint them, my lord. Because the matter has to
my
be.
senior before passing that order, Lordship.
So,
Mr.
my lord,
he will be appearing in this matter, Lord.
No, but I will be passing the order now. Whether when he will be appearing, I'm not concerned. Call him wherever he is.
Lordship, he is
Call
on
him.
legs in.
That we can't help it.
Point number 1 and 2, my lord.
Call him if he wants to come. Mr. We'll take it after 10 minutes. If he's around, we'll hear him. But this matter will pass an order after 10 minutes.
Lordship,
Or we'll do it at 12.
Lordship.
At 12.
Lordship.
Order impeachment of party, I don't.
None appears for the applicant when the matter is called up. In view of the above, his highest stands adjourned for 2 weeks. Yes.
For admission, item 18.
Lordship, before my learned senior starts, Your Lordship, I beg an apology, Your Lordship. Actually, we are suffering from some problem in the sense that we have not got the file from we're not able to trace the file in the office, Your Lordship. If 1 or 2 days time is given, Your Lordship, it will be very grateful, Your Lordship. Some records were also there in the file which we have given in the court also, Your Lordship.
What is this matter about?
Personally,
relates to selection to the post of supervisor in the social welfare department in the category of physically handicapped people. There was no selection made. Nobody was appointed. And that was the issue raised that I belong to that category. Even there was none who was selected. How can it be? And that's how I came before this honorable court. Then they exchanged 3 affidavits. Firstly, they said that I was not qualified. Then they said none appeared in this category. Then they said, no, some people have been selected. And this honorable court directed that you produce all records because of this controversy. And ultimately a sheet was prepared where also they could not file anything regarding me and the person who have been appointed their marks. So ultimately, I had to file again the last affidavit. So all these are there. So it appears prima facie that there was no selection made in that category and no one was appointed. So if it is found, this honorable court finds that now that was an illegality committed, they could not have avoided selection or appointment in that category. They will have to be directed that the person who secures the mark, eligibility, he should be appointed amongst all if somebody has already done. Otherwise, I am being the contender. They should consider my case.
What do you have to say on his predicament?
Predicament, my lord, as I find it, this matter belongs to 2016. And every time that predicament appeared, there may be some genuine cause also, but I don't say. But then that should not have been, because this case has been in the list of the board for days together, and it needs disposal. 2016.
Lordship, I have no cavil with this. True, Your Lordship. Just 1 or 2 days, that's why I'm seeking Your Lordship, because whatever records were there with us also, that also we have to look into, Your Lordship. We are doing with the B file today, Your Lordship.
On Friday, Lordship may take up.
Lordship.
No, it cannot be before 16th May.
16th May.
16th, before that it is not, because this is not convenient for the court.
I see. And 16th May, my lord, It would go for this 3 weeks almost. Anyhow,
Because the week
Lordship may
commencing
fix it
from-
on 18th.
Or we can put it on 11th May if you want, 11th of May.
Yes,
11th May is fine
us-
with you? 11th May?
yes, 11th May.
Acha,
Thursday.
we'll make an observation that on next date, no
Yes.
adjournment. Mr. K.K. Mohandan, Senior Counsel appearing for the writ petitioner. When this matter was called up for admission hearing today, Mr. C.S. Hazarika, learned government advocate, submits that the relevant records have been misplaced in the office of the government advocate Assam, and therefore he be given a week's time to reconstruct trace out the record, reconstruct the records for arguing the matter. Full stop. Although this writ petition pertains to the year 2016 and therefore calls for expeditious disposal, yet in view of the ground on which the prayer for adjournment is made, the same stands allowed as a last chance. Full stop. Register to therefore list this matter on 11/5/2023 as a fixed item for admission hearing. It is made clear that no adjournment on the ground of non-availability of record will be allowed on the next date fixed.
Oblige, your lordship.
Oblige.
18 minutes.
May I please, your lordship? Lord, in this case, my lord, we were directed to take instruction from, my lord, our client. My lord, the instruction that we received, my lord, that, my lord, he has been removed from service. As per the order passed by the director, my lord, order dated 6 January 2023. My lord, there was a departmental inquiry, my lord.
So he has been removed from service.
My lord.
You have to challenge that order of removal
Yes,
from
my lord.
service.
We have preferred appeal against that order, my lord, before the governing council, my lord, Tata Memorial Center.
Okay.
It is pending, my lord, for this one.
So
That
what
is-
you want to do? This will entail further delay. Why don't you challenge the order of removal?
That we have preferred appeal, my lord, before the.
All right, then you wait till the appeal is
My lord.
maybe 1 or 2 years. He wants to wait.
The
matter
has
become infructuous, my lord.
That's correct.
But let us wait for the outcome of the, my lord. appeal.
All right, all right, all right.
So far,
Because-
my lord, the merit of the case, he has been removed. He may have a good case.
But what to do? He's not,
I
he's
just don't
not picking
understand.
up on the suggestion coming from the court. What to do? This is unfortunate.
Exactly.
He is not willing to do something to give relief to his client. Mr. B.K. Sen, learned counsel for the petitioner, has appeared and submits that in terms of the instructions obtained on the basis of order dated 10/3/2023. He has been informed by his client that the writ petitioner has been removed from service during the pendency of this writ petition. Full stop. If that be so, the submission of Mr. S. Datta, learned senior counsel, appearing for respond numbers 2 to 4, to the effect that the writ petition has become infructuous, appears to be prima facie correct. Full stop. Now, the petitioner will have to challenge the order of removal from service. Full stop. However, on a pointed query made by this court, Mr. Sen submits that since an appeal against the order of removal from service is pending before the appellate authority of the Tata, what is it, Tata?
My lord, governing council, Tata Memorial
Governing
Center.
Council of
Mumbai.
Tata Memorial
Center.
Center, Mumbai, till disposal of the appeal, the petitioner is reluctant to take any further step in the matter. If that be so, by granting liberty to the petitioner to assail the order of removal from service, as well as by taking all legal grounds, including those asserted in the present writ petition, this matter stands closed. As
Obliged.
success. Miss D.
I am
Bora,
obliged, my lord.
Ms. D. Bora, learned Standing Counsel, Health and Family Welfare Department, Assam, is appeared for the respond number 1. Mr. S. Datta, assisted by Mr. S. Datta.
Obliged.
Item 20 and 21.
Under the petitioner, my lord, he is a person with disability. And a selection drive was conducted, my lord, wherein 26 numbers of candidates were selected. And the petitioner was one of them, my lord. Subsequently, another medical test was conducted by a special board. And thereafter, the candidature of the petitioner was rejected, saying that the petitioner's disability is less than 40%.
But according to you, petitioner's disability is?
The petitioner, more than it is 40%. There is a certificate granted by the medical authority, my lord. If I may take your lordship to the certificate, page 22 of the writ petition, my lord. This is certificate, my lord, purportedly issued under Rule 4 of the Persons with Disabilities Rules, my lord, 1969. It is at page 23, my lord, will see it is signed by the medical authority, medical and health officer of SMCC Civil Hospital, Nalbari. Now, my lord, if my lord comes to page 40 for a moment, that is the order rejecting the candidature of the petitioner. Further, it may be mentioned here.
Yes.
Further, it may be mentioned here that the following two candidates selected in the special recruitment drive for the persons with disabilities whose disability is less than 40% as authenticated by the Joint Director Health Services Kamrup Metro has been rejected, and therefore you are requested kindly not to issue their appointment letters. Now, the health department have filed their affidavit, matter saying that the special
recruitment is for what post?
For the petitioner, he was selected for the post of junior assistant in the Department of Water Resources.
Both of them.
The other petitioner was selected in the Agriculture Department.
Same process of appointment. Same advertisement.
Same order.
Same advertisement.
Yes, ma'am. Same advertisement.
And both of them locomotor 40%.
Locomotor 40%. They were granted a certificate by the competent medical authority, my lord, and thereafter the test. Is
there any interim order here?
An order was there, my lord, to keep one post vacant, my lord, not to be filled, my lord.
One each.
One each. Now the health department has come up with an affidavit, my lord. And at page 7 of the affidavit, filed on my lord 1/3/21. This is in letter, my lord. Their stand is that, my lord, the special medical board was constituted, my lord. With reference to the subject cited above, I would like to inform you that as desired by the government for constitution of a special medical board to verify the complaint about the authenticity of the certificates of the selected candidates for appointment to the grade 3 post in various departments in connection with special recruitment drive for persons with disabilities category selected by the state levels police recruitment board Assam and conducted by the social welfare department, you are hereby requested kindly to constitute a special medical board and fix a suitable date and intimate the undersigned for taking. Now, here it is said that there were certain complaints, and with regard to the complaints, a special medical board was constituted. Now, if I may take your lordship to the persons with disabilities rules, my lord, there is a procedure. If there are certain complaints with regard to persons with disabilities, then certain procedures has to be complied, not by instituting a special medical board. They would pay if rule, my lord. Rules 42. In my book, it is page 39, my lord. Rule 42. Persons with disabilities.
Yes.
Rule 42. Procedure to be followed by the chief commissioner a complaint containing the following particulars be presented by the complaint in the person or by his agent to the Chief Commissioner of Persons with Disabilities or by sent by registered post address to the Chief Commissioner. Then he have to give the name of the complainant, all these things, my lord. I would like to take your lordship to 42 sub-rule 2, my lord. The Chief Commissioner on receipt of a complaint shall refer a copy of the complaint to the opposite party or parties mentioned in the complaint, directing him to give his version of the case within a period of 30 days or such extended period not exceeding 15 days as may be granted by the Chief Commissioner. Well, no such drive was conducted, my lord. No, if the petitioner, my lord, he was not given any opportunity to place his case, my lord. And
So, yes, no?
yes, my lord. Now, for a moment,
What is the reason why they were not appointed? Where is the reason?
That reason, my lord, that the petitioner, my lord, he is less than 40%. Less than his disability is less than 40%. That is their contention, my lord.
Where is it? Which page?
My lord, in the writ petition page 40, my lord. The order rejecting the candidature of the petitioner, my lord, page 40. Here it says, my lord, further it may be mentioned, third line, whose disability is less than 40% as authenticated by the Joint Director Health Services, Kamrup Metro. That is the reason, my lord, that the petitioner's disability is less than 40%. We also have filed our reply to the affidavit filed by the Health Department, my lord, on 5/12/2022. Yeah, if I may take your lordship to page 58, this is persons with disability hobo 40% লাগিব. If I may take your lordship to page 57 of my affidavit in reply, man. This is a certificate issued, my lord, by the medical officer and health officer, my lord, saying that the disability is 40% and it was.
So, is it your case now that they should follow the requirement of Rule 42 and then come to a decision if there is a complaint about the extent
That
of?
is the procedure, my lord. And apart from that, my lord, what I'm saying is at page 57, this is also in medical certificate, my lord, issued by a competent authority saying that his disability is 40%. And this certificate was issued on 29/11/2022. And the candidature of the petitioner was rejected, my lord, on 2nd January 2020. And further, my lord, the certificate of disability granted to the petitioner was in the year 2017. And
Yes, what do you have to say? The certificate says 40%.
Certificate is of 2017, lordship, and medical board was constituted. Medical board was constituted on 22/11/19. Actually, after 2 years, lordship. So maybe he may be the disability may be some sort of, he may be improved.
There is a
lordship.
certificate of 2022 also, page 57, which again says 40%.
I have already stated in my affidavit, lordship, para 4, lordship.
No, you see, what you have stated is fine, but the government document certificate says 40%.
40%.
Another set of certificates says not 40%. What is the court supposed to do?
This we have done only that annexure 1 of my affidavit on the direction of the Director of Social Welfare. Medical board has constituted, lordship, and after that it is verified. And they found it that the petitioner was on 11% of permanent physical impairment.
And where is the advertisement?
Advertisement.
And we are not the appointing authority.
Page 14 of
Appointing
the
authority is the social
Page
welfare department.
14 of the writ petition.
What does it say? It should be minimum 40%.
My lord, the act, my lord, a person with disabilities, my lord, he has to have
Section 3.
mine, section 2, my lord.
So your certificate issued by the hospital say 40%.
40%.
Medical board says 11%.
Yes.
Only,
Now,
we should toss a coin and
now the
find who is correct.
it has to be issued by a medical authority, my lord. Medical authority is also defined in the act, my lord. Medical authority means any hospital or institution specified for the purpose of this act by notification by the appropriate government. Merely by instituting a special medical board.
So what is the order you want today? There can't be an order to appoint you, obviously.
Yes.
What order you
Well,
want?
we are challenging this order of rejection of the writ petitioner, my lord.
Then we'll hear it, admit the writ petition and hear it. What can be done?
And one more aspect I would like to bring to your lordship, my lord, notice, my lord. If my lord takes up my affidavit and reply, my lord.
You are not ready to get an order. You are only going on saying and saying and saying. If you keep saying and saying, we'll post it for hearing. What is the solution? What order you are seeking today? If it is a final hearing, we'll do it some other day, not today.
One aspect, if a lordship permits me, my lord, an RTI application was made, my lord, and a reply was given, my lord. At page 59, my lord.
Mr.
Page
Munir,
15,
you are a counsel in the court. You must anticipate what is the situation. Tell the court, this is the order that can be passed. Please pass this order. You are going on saying and saying and saying. We'll hear it some other day. Admission matters can't be heard for more than 5-7 minutes. This will require full length hearing then. You don't have a solution. You want a setting aside at the order.
where
That will take time. That we can't do it today. Then we'll admit it and put it on a hearing on a non-miscellaneous day.
it will be, it is a selection process of 2020, my lord.
Not
And-
today.
and-
Today you have to say what is the quick order which can be passed here. You are not able to say that. You must not even have thought about it.
But then can it be like that? Now, there are certificates which says 40% and they are saying it's less than 40%. Let them verify, my lord, and
Who will verify?
let them constitute a board, my lord.
Under
Let-
which
let
rule?
him- Let him be,
Under which rule?
my lord, rule 42.
Why should there be another board? Why should that board not be treated as rule 42?
My lord, it is, no, this is not a board under 42, my lord. It is the commissioner of persons with disabilities. There, my lord, there is a procedure, my lord.
42 does not call for a board, is
But
it?
it says, my lord, if there are complaints and from the order, it is seen that there are complaints, my lord. And to address the complaint, there is a procedure.
No, but nobody has made a complaint against you.
Yes, my lord.
Where is the complaint?
I do not have the complaint, my lord, but the order it says, my lord. Sorry. Page 7, my lord, of their affidavit, my lord. Page 7. With reference to the subject cited above, I would like to inform you that as desired by the government for constitution of the special board to verify the complaint about the authenticity of the certificates. The authenticity of the.
Where are you reading from? Where are you? reading?
I'm sorry, your lordship. Page 7 of the affidavit filed by the health department. With reference to the subject cited above, I would like to inform you that as desired by the government for constitution of special medical board to verify the complaint about the authenticity of the certificates. To
verify the authenticity of the certificates, there is a procedure, rule 42, my lord.
Yes,
They-
what do you have to say on this? Rule 42? Okay, now you will go through the rules. Make your interpretation, make your submissions.
Sorry, let's.
On the prayer of learned counsel for both the parties, let these matters be listed again in the next week as fixed items for admission. Report the heard Mr. So and so for so and so, so and so. So as to enable the learned departmental council to obtain instruction and appraise this court as to why a direction should not be issued to subject the case of the petitioners for examination by a committee as envisaged by Rule 42 of the persons with disabilities, bracket equal opportunities, protection of rights and full participation, bracket close rules 1996. Good stuff. We'll pass an order next week. Please come prepared, huh? You can't open the book, start reading the law and then make submission in this court.
My lord, the interim
Don't even dream of such a report.
in-
That is not going to happen here. If you want to say something, please come prepared.
my lord, the interim order may be continued.
Interim order passed earlier to be. After 2 weeks, make it after 2 weeks.
2 weeks.
Yes.
May it please your lord.
My senior is out of station. Our part maybe heard some other time.
What our part, his part. Then what is this matter about?
Matter is very small matter, your lordship. What I have been done, I am a masteral worker. And initially I was given, as per the Honorable Division Bench judgment, I was given the regular pay scale. Then they reverted me to
Minimum
fixed
pay scale.
minimum of pay scale. They reverted me to the fixed pay scale. And therefore I came before this honorable court. In this honorable court, your lordship, they said that the order specifies that minimum of pay scale. Because the word of is there, I am not entitled to the minimum pay scale, therefore I am given that.
Which order specified minimum of pay scale?
Minimum of pay scale, your lordship will find the judgment of the Honorable Division Bench that I have given a copy on the last occasion. I think
Yes,
it is there. Yes.
Yes.
That with that copy, your lordship, penultimate para of that. Para 22. It is, however, heartening to learn that the state government has agreed not to terminate the master works of so working since last 10 years, not sanctioned for. It is their normal retirement except on disciplinary ground or ground of criminal offense. The state government has also agreed to enlist such employees in health and accidental death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate this positive stand of the state government taken as welfare measure for the betterment of the security of the employees in question. We accordingly direct the state government to implement the measures without further delay. Besides this, we, in the light of the decision of the Honorable Supreme Court in the state of Punjab versus Jagjit Singh, also direct the state government to pay minimum of pay scale to master roll workers, work charge so and so, not more than 10 years. There is no dispute with regard to we are all appointed prior to 1991. There is only thing they are interpreted in their affidavit. If your lordship take up their affidavit, that affidavit was filed recently, your lordship, that was in 2022, September 2022. This affidavit, your lordship, will kindly see para page 80. Page 80, your lordship will see, that is para 8, order the second paragraph, page 80. Just see how they have interpreted, your lordship. Further, the Finance Department, after a closer reading of the orders of the Honorable High Court, observed that as per order of Honorable High Court dated so and so, these set of employees are not supposed to be extended the benefit of minimum pay scale, but fixed amount pegged at a minimum of the pay scale. Now the word of has changed the whole issue. They have
You are right, but
and the
whether-
judgment.
Listen, Mr. You are right.
Yes.
But whether you do it today or after 2 years, this clarification has to be obtained from the division bench. This is going to create problem not only for your client, but for a large number of.
Yes.
The idea appears to be minimum pay scale,
Yes.
but this word off is coming.
That is why I consulted the judgment of the
Doesn't
Honorable
make
Supreme
any
Court.
sense. Minimum of pay scale does not make any sense.
No, the
But
pay
then-
scale is a pay scale.
Correct.
Yes.
You are right.
Hmm.
But this court cannot give you the relief. That's the problem.
But the Honorable Supreme
That's
Court.
the problem.
I understand.
Judgments of the court orders of the court are to be interpreted in literal sense. No question of interpretation of judgment of court order. That is the law.
No, they have changed the interpretation.
Minimum of pay scale means not the minimum pay scale. That's their interpretation, and
The Honorable Supreme Court says the minimum of pay scale means the pay scale.
correct, but that observation has to come from the division bench. Because the law is very clear, the court can or others can interpret a statute, but there is no scope of interpreting of a judgment.
Absolutely
Judgment
correct.
has to
I'm
follow-
not saying the interpretation has to be made. That the interpretation was clear. They have given us the scale, but suddenly again reverted.
Anyway, you think about it, because
Yeah.
at the end of the day, this court will not change the
I
order
understand.
passed by.
I
the-
understand your lordship has what has.
It's a
but
simple.
That is
thing.
why I consulted the judgment on the which this 2017 judgment that referred by the Honorable Division Bench. Their judgment stated in bracket, when it stated minimum of pay scale, in the bracket, it's reiterated.
So that to the division bench and get a clarification.
Then have to go for a. some
Yes,
kind of a-
that should have been done at that stage. 2023
Yes.
years have gone.
Because
How
at
many
that
more
time,
years? Yes.
at that time, they were given the scale. Nobody was.
So therefore, you put it before the DB and get a clarification, matter over. Do you have any other option? You think you have another option?
I don't know, your lordship. Let it be fixed after some time, for some few days.
Whatever has been written
If
in the
in
DB
between we
judgment,
find that
how can
somebody
they
has
say-
taken it up before the division bench, then
yes.
it will be well and good.
Has
I
anybody
don't know.
moved?
I don't know as of today.
It appears to be an inadvertent inclusion of a particular, word off.
No,
Off
it is
office
my-
there, office there in
Yes,
the,
in Jagdish Singh's case, my lord.
it is office there in Jagdish Singh's
No, but
case.
that clarificatory expression was not there.
But clarification is there in this.
No,
Here
but
it says in the
but here
Jagdish
it is
Singh's
not
case.
there. In the DB judgment.
DB judgment it not say, but in the clarification is there in the Jagdish Singh's case. That is why I bought this judgment also. It says, in the present bunch of cases would be entitled to draw
Your-
wages
your
at the minimum of.
arguments- Your arguments are very correct.
Yes.
Only thing is you are in the wrong address. If you want to press, then I'll pass an order.
I don't want to press anything.
No, but what is the way out? How can
No,
a single bench?
I'm said that if
How can
somebody
the
has
single
already
bench-
approached the DB, let me verify that. Your lordship may keep it
Verify.
after some time.
But I agree with your submission. You're right on that. You're right on that. This doesn't make any sense. Minimum of pay scale means the minimum pay scale.
Yes.
That is the idea.
Minimum of that pay scale,
Yes.
particularly that. Simple
Whatever is
as
the
that.
pay scale applicable to.
But it
master or
cannot
worker.
be fixed pay. That is the difference.
No, that will abridge the whole idea of the judgment of DB.
But that we will
But
explain. my lord.
finance department will pounce upon it. It
No,
means
we
the
are
fee
not
under-
afraid of the finance department.
it's
We are
not-
not afraid of that.
It's not a
But
question-
the question is that small
It's
office
not a
created.
question of being afraid. If they get that loophole, it means a few 100 crores to them.
Yes.
They will latch on to it until they are compelled
That-
to
yes.
let it go. And the only way to do it is get a clarification from the DB.
Let me verify if somebody has filed some cases before. the
Verify.
DP also. Let me find out. You also may keep it after some.
Verify, or if you make a submission, then in any case, you have
Because in
filed a
any case,
review.
your lordship is not going to interpret anything.
It cannot
therefore-
be done. It cannot be done.
Yes.
Single
Therefore,
judge cannot-
let it be after some weeks.
Single
In
judge
the
cannot
meanwhile, I'll
say
pick
what
it
the division bench actually intended. That's not permissible under the law. You think about it, you want it to be posted again.
Not today, let it be some other day. In the meanwhile, let me go through if there is some matters pending or filed before the DB.
Then you will need 2 weeks time at least. All right. Mr. Y.S. Manala, counsel is present on the petitioner. Mr. P. Karkati, Land Standing Council, WR Department, appearing for the official respondent 6 posting of this matter again after 2 weeks on the ground that the learned additional AG appearing in this case is out of station. Mr. B. Gogoi, learned SC Finance is also present, and 6 posting of this matter after 2 weeks. In view of the above, this matter stands adjourned for 2 weeks. You examine the matter, find out if somebody is approved. Because that way it will.
Item 17.
Yes.
Lordship, there are 6 petitioners, Lordship. If 6 posts can be kept vacant, Lordship, and the others maybe filled up, Lordship.
No, result were declared out of 6, my lord, 4 were get
Result.
so that's why, my lord.
Four are in the
Yes,
list of
it's
successful
elected.
candidates.
4 are out, 2 are out of context.
So two vacancies can be kept reserved.
My lord, 4. 4
Out of 4,
out of 6, 4 were, my lord, get selected, my lord.
So if they're selected, they will proceed as per this merit list. What else?
No, my lord. They are not eligible to sit in the examination also, my lord. They are not eligible candidate, my lord. Their subject matter is, my lord, that has to be decided, my lord. But because of these 4, my lord, because they are, my lord, they are degree holder. Degree holder are not presuppose, my lord, diploma holder. This post is exclusively for the as per the
Who are the 4 who have been selected?
my lord, that's it. Already they are, my lord. Select list is there, my lord.
Select list has been published.
As there is a direction from your lordship, my lord.
Okay. Who are the 4 who have been selected?
That is, I have named, my lord, that is last page, my lord, your lordship kindly see. 2, 3, 4, 5, and 6.
2, 3, 4, 5.
3 to 4, 5.
They are petitioner numbers.
Yes, we have petitioner numbers. Petitioner numbers, idea. Kuldeep Burma. Petitioner number 2, Kuldeep Burma. Petitioner number 2, sorry. Petitioner number 2. 2, then, and Pankaj classman.
Yes, please tell me who are the 4 petitioners. You can't.
P2, P, Pankaj Kumar, 6, and Vedanta Bhardas.
Let me do it myself. Mr. Sharma, you are unable to say which are the 4 petitioners.
2, 4, 5, and 6.
2, 4,
5, and 6. Last page, my lord, that result sheet, last page, it will be very clear, my lord. Your lordship will see. Your lordship can name that also, my lord. Petitioner number 2, petitioner number 4, petitioner number 6, and petitioner number 5. 5, 6, 2, 4.
They were all provisionally allowed to
by the Harshop court order, they were appearing in the interview, my lord.
Take down. Heard Mr. MP Sharma, learned counsel appearing for the writ petitioner. Also heard Mr. TJ Mohanta, learned senior counsel assisted by Mr. PD Datta, learned standing counsel APSC appearing for respondent number 7. Miss MD Bora, learned government advocate. 4 and 7. 4 and 7. 4, 5, 6 and 7. 4, 5, 6 and 7. Ms. MD Bora, learned standing counsel, Transport Department, Assam, has appeared for respond numbers.
8, 9, and 10 in the IA, my lord.
No, on the writ petition. Yeah.
1, 2, and 3.
1, 2, and 3. Full stop. The 6 writ petitioners in this writ petition were denied admission into the selection process initiated by the authorities for filling up 27 vacant posts of MBIs in terms of the advertisement notice dated,
13/10/2000.
advertisement notice dated,
13.
it is written 25.
2022.
13/10.
25/5/2020.
In terms of the advertisement notice number 10/2022 dated 25/5/2022. Full stop.
Total post 26.
26.
26 put through advertisement, 26.
Acha, 26 post. Aggrieved thereby, the writ petitioners had approached this court inter alia contending that their qualifications were sufficient to their qualifications constitute sufficient. No, the contending that as per the qualifications,
They are not eligible to. Page 32. Page 32, the advertisement is.
contending that they were eligible to take part in the selection process. First up. Taking note of the contention of the writ petitioners, this court had passed an interim order dated 27/6/2022, provisionally permitting the petitioners to participate in the selection process. Accordingly, the petitioners participated in the selection process. Yeah, accordingly, however, the authorities were directed not to publish the final results of the selection process. Accordingly, the 6 writ petitioners had participated in the selection process. First up, after conclusion of the process, the respondent number 4 had approached this court by filing IAC C number 441. Respondent number 4 as applicant had approached this court by filing after conclusion of the selection process, the Assam Public Service Commission as well as the secretary to the APSC as applicants had approached this court by filing IA bracket C bracket close number 441 public 2023 with a prayer to modify the interim order dated 27/6/2022 passed in WPC number 4281 of 2022 and allow the APSC to declare the final results of the selection process. First up, the said prayer was allowed by this court by order dated 12/4/2023, whereafter the results were published
On 24th April 2020.
on 24/4/2023. First up, Mr. Mohanto has placed the final select list in a sealed cover and submits that 4 out of the 6 writ petitioners have emerged as successful in the selection process. First up, however, until such time, the question of their eligibility is finally decided by this court, no order of appointment can be issued in their favor. First up, Mr. Mohanto, that is senior counsel for the APSC, further submits that since the other 2 writ petitioners did not qualify on merit in the selection process, hence no relief can be granted to them in the writ petition. First up, Mr. Sharma, learned counsel for the writ petitioners, has also fairly submitted that the only question now that would arise for consideration of this court is as to whether the 4 writ petitioners, namely the petitioner numbers 2, 4, 5, and 6, whose names find place in the final select list, would be entitled to, were eligible to participate in the selection process, and to that extent would be entitled to issuance of appointment orders in their favor. Full stop. The aforesaid aspect of the matter can be decided at the time of final hearing of the writ petition. Full stop. In view of the above, and after taking the note of the submissions made by learned counsel for both the sides, the APSC is hereby granted leave. No, the respondents are hereby granted leave to fill up 22 posts of MBI by operating the select list dated 24/4/2023. Full stop. However, 4 posts of MBI shall be kept vacant, awaiting further orders in the writ petition. Full stop. It is made clear that the respondents shall also keep alive. There is a wait list.
No, there is no, nowadays there is no wait list.
Acha. In view of the urgency involved in the matter.
We should keep alive the merit list. There is a merit list, but we can publish only one same number of postmen.
It is also made clear that the respondent shall keep the merit list alive. Merit list, select list alive for a further period of 6 months with effect from today, awaiting final order in this writ petition. With the above observation, the order dated 12/4/2023 passed in IS Civil 441 of 2023 stands modified. It order to writ petition on IS Dutata Dekhabo. Registered to list the connected appeal for final hearing.
This case disposal.
In the month of in the first week of June 2023 on a non-miscellaneous day. The IS stands disposed of with the above observation. The written instruction dated 25/4/2023 produced by Ms. M.D. Bora, Learned Standing Council Transport Department, Assam, shall form part of the record of the IA.
Item 23.
Maybe your lordship. Lordship, in this case, your lordship is one judgment. This case is covered. I'm forwarding this.
Is it covered by this order?
In this case, lordship, petition number 2, 3, 7, 10, 11, then 16, 13, 16, 18. These persons are covered, lordship.
I have to go through it. We have filed an affidavit also in this case, my lord. They are not come in the merit list, my lord.
No, that is why they have come to the court.
Yes, my lord.
They want an order that they should be treated in the merit list. That much we know.
Yes, ma'am.
Otherwise, why would they come to the court? You go through the order, we'll see. After some time, we'll take up.
Yes, ma'am.
You give us the names of which are the petitioners according
Yes.
to you.
Item 24 and 25.
Also, in this case, as per my instruction, the petitioners are covered by the earlier judgment of this honorable court. They are entitled to.
All the petitioners.
All the petitioners.
Which is the earlier judgment?
In item number 24, I have given one comparative statement on the last occasion. So I have highlighted the persons who are eligible in that. I'm following this one once again. The highlighted persons are eligible also. As per this.
So according to you, everybody is not eligible. According to her, everybody is eligible.
Yes, Lordship, as per my instruction, Lordship.
What to do?
Yes.
He doesn't want relief for all petitioners. You want,
Yes.
I will record it.
Lordship.
So how many petitioners are there in this case?
In this case, total 11.
14.
There is no clear response on anything. You don't even know how many petitioners are there. Somebody say 11, somebody say
it's
14.
14.
Huh?
14.
You have given the list of only 10.
Next page also.
So all 14 are eligible.
No, I have highlighted Lordship who are eligible. I have highlighted. Those are eligible.
Only 4 are eligible.
Yes, Lordship. They scored more marks than the general category candidates.
And what is the petitioner number here?
It is as per the list, Lordship.
Take down. Heard Mr. R. Sharma, learned counsel for the lead petitioner. Also heard Ms. L. Devi, learned CGC appearing for the respondents. Full stop. The read petitioners herein, numbering 14 in total, had earlier participated in the recruitment process for appointment of, in the selection process for recruitment of constable bracket GD bracket close in Central Armed Police Forces bracket CAPF small s by any capital small s bracket close comma NIA and SSF as well as riflemen bracket GD bracket close in the Assam Rifles. Full stop. The selection process was conducted by the Staff Selection Commission bracket SSC in terms of the advertisement notice dated 21/7/2018. Full stop. The read petitioners will hail from the northeastern region and belong to the reserve category of candidates. Full stop. During this selection process, some relaxation was given to the petitioners in respect of the physical standards insofar as measurement of their chest and height, etc. is concerned as per the notified policy of the respondents. Full stop. When the final, on conclusion of the selection process, the petitioners claim to have scored more marks than the general category of candidates. However, their names were not included in the final select list, allegedly on account of the fact that having already availed relaxation in assessing their chest oblique height, the petitioners could not claim further relaxation. Full stop. Mr. Sharma submits that the aforesaid aspect of the matter came up for consideration before this court in a number of writ petitions, wherein this court has clarified that relaxation in their chest measurement and height given to the candidates coming from northeastern region cannot be treated as relaxation, cannot take away the advantage of merit position secured by the petitioners in the overall selection process. And therefore, the impugn action on the part of the respondent authorities in not including the name of the writ petitioners in the select list is illegal, full stop. By producing a copy of the order dated 7/6/2022 passed by this court in WPC number 1684 of 2021, and another order dated, what is the date? Dated so and so, passed in WPC number so and so. Mr. Sharma submits that the petitioner numbers 3, 9, 10, and 14 would be entitled to a similar order directing the authorities to consider their cases on merit and accommodate them against available vacancies. Full stop. The aforesaid orders were passed by taking note of the law laid down in the case of Hemant Pokhriyal versus Staff Selection Commission and others. Triple bracket WPC number 4982/2021. Triple bracket close. Decided on 1/10/2021. Full stop. Miss L. Devi, learned CGC, R. Devi, learned CGC, submits some instruction that not only the respondent numbers, not only the petitioner numbers 3, 9, 10, and 14, but all the writ petitioners would be entitled, as per records, all the writ petitioners would be entitled to the benefit of similar orders passed by this court earlier. Full stop. A perusal of the by the orders, by the order dated so and so, the learned single judge, while relying upon the decision rendered in the case of Hemant Pokhriyal, had made the following directions. Para 14 of Hemant Pokhriyal Supra had made the following direction. So where is the other order? Give me the other order.
This one. WBC 1684/2021.
In another order passed in WPC number 1719 of 2021. This court had disposed of the writ petition. Where is the order of this court? Can you please, where is the order of this court?
I have given Vipul Burman. That only. That was
Give it back.
WBC 74 of 2023.
In another writ petition bearing WPC number 74 of the 2023, this court had passed Similar order dated 25/1/2023. With the following directions. Full stop. Since there is no dispute at the bar that the case of the writ petitioners are, since the stand of the CGC that case of all the writ petitioners are covered by the aforementioned two judgments of this court. Hence, I dispose of this writ petition with a direction that the cases of the writ petitioners shall also be considered in the light of the observations made in the order within 6 months from the date of receipt of a certified copy of this order. The writ petition stands disposed of accordingly. And what is the other, which is the
73, my lord, same, covered judgment.
item number?
23, my lord.
Item 23, the petitioner name is same. CGC will be Miss A. Gayan. And all petitioners are
No, my
entitled.
lord,
237, 10, 11, 13, 16, and 18.
Acha, item 23, Libo, petitioner numbers 2,
3,
7,
10,
10,
11,
11,
13,
13,
16,
16,
18.
and 18. If any Miss Gayan submits that the writ petitioner numbers so and so, and any number in your book. As per records, the writ petition number so and so will be entitled to similar relief. Goal.
My lord, 25, my lord. I am in 25. my lord.
And in 25,
B Sharma.
B Sharma,
My lord.
all
All
petitioners.
petitioners.
ইয়াতে all petitioners হ'ব আৰু একেখিনি তাতে তিনটা order এইখিনি changes
Obliged.
Obliged.
disposed of গোটেইকেইটা give to him এইটো ঘূৰাই দিলে হ'ল।
Item 26.
My lord, the issue involved.
Hmm.
The issue involved herein is, my lord, is that the persons, my lord, who were recruited against vacancies of 2003, but then their appointment came in 2004, whether these persons will be covered under the old pension scheme or the new pension scheme, my lord. The law has been already laid down, my lord, the several judgments from the Delhi High Court and one including of our division bench of this High Court has laid down that these persons, my lord, who were recruited against vacancies of 2003, but even though they were appointed after 2004, they will be, my lord, covered under the old pension scheme. Accordingly, my lord, I have filed an additional affidavit when the matter came up before consideration. The court had directed that additional affidavit bringing in this development should be filed. In fact, the DOPT has also now brought out a circular that all persons now should be given an option of exercising that option if he wants to go to the old pension scheme within 31st of August, my lord, he should exercise that option, my lord. Accordingly, the issue is, my lord, settled, my lord, according to my submission.
Lordship, in petitioner's case, advertisement was issued before coming into effect of the NPS, Lordship, but their recruitment process was initiated after Lordship, 1st January 2004, after the NPS come into effect. Therefore, they are not eligible for old pension.
Is his case covered under the previous judgment of the court?
Lordship, in this case, additional affidavit filed only yesterday, Lordship. I will take instruction.
In fact, some matters from Assam Rifle were in the Delhi High Court. In those cases, my lord, they have.
Yes, the problem is she's not aware, so
Yes.
you have to give her some time. How
Well,
Mr.
well,
B.
definitely.
Patil, counsel for the petitioner, who submits by referring to the additional affidavit filed by the petitioners that after the decisions of the Delhi High Court as well as this court covering settling the matter, the petitioners and in view of the circular issued by the DOPT dated
DOPT, my lord,
circular dated
3rd March 2023.
3rd March 2023 issued by the DOPT, Government of India. The controversy involved in this writ petition can be resolved by providing that it will be open to the petitioners to opt for either the old pension scheme or the new pension scheme. Although they would otherwise be entitled to be covered under the old pension schemes, since the vacancies against which the petitioners were recruited arose in the year 2003. That is prior to notification of the new pension scheme. Ms. R. Devi Leonard CGC 6, 10 days time to obtain further instruction on the additional affidavit. In view of the above, let this matter be listed again after 2 weeks so as to enable the Leonard CGC to obtain instruction facilitating disposal of the writ petition at the stage of admission hearing.
On this matter, Madam, though I was directed to file an affidavit, and I have instructions. We support the case of the petitioner, but in fact, it is the finance department against which the my lord grievance lies, because their proposals for their my lord regularization was sent to finance department, and my lord, it has been returned back. No, Madhavi, my lord, and Upenda. The proposal was submitted in 2021. Umadevi came in 2006. Last such regularization, my lord, as per policy decision was made in 2005. Petitioner was left out, probably, and it's their case.
No, but if you are left out for a reason which is not genuine, then you have to give him the same benefit. Otherwise, this will be disastrous. Somebody will be malefiedly left out, and then you will say that.
The malefied, that part, my lord, of course, my lord, she will have to establish, my lord, in the proceeding.
You are not filing any affidavit.
But we have filed the affidavit. We have given her stand, my lord, that pursuant to my lord Umadevi, after Umadevi, my lord, we are not in a position, my lord. In fact, my lord, for left out also, my lord, there was a writ petition, my lord, at that point of time. We preferred a miscellaneous application before the division bench, thinking that will my lord regularize those left out ones. The honorable division bench of this honorable court finally said that, my lord, if the Supreme Court does not permit, how this honorable court?
Where is that order?
Yes, we have. Probably I will have to place it, but we have mentioned it in our affidavit.
Have you seen that order?
Well, it will be page 55 of the affidavit that we have filed. Filed by respondent number 2. Lordship will see the last second paragraph.
Yes.
Last second, if the state cannot regularize casual workers as per law laid down by the Honorable Supreme Court, we fail to understand how we can give direction to adopt a policy which may be in violation of the judgment of the Honorable Supreme Court. We accordingly decline to grant the prayer. So we sought for leave.
Next, Lordship.
It is, however, made clear that it is the responsibility of state to appoint employees in accordance with law or to make any other arrangement for properly
For hygiene.
hygiene and sanitation in jails. That's a separate issue. But my lord, it was, my lord, an endeavor was made. My
So
lord.
what happened? His name, some people were regularized.
Some were regularized, my lord, pursuant to the policy decision of 22/7/2005. Regularization was issued on 22/8/2005.
Yes.
About 25,000 persons were, my lord, regularized.
So petitioner was left out.
Probably that is the case of the irrigation department, my lord. Inadvertently, most probably it was left out. But since, my lord, Umadevi said, my lord, there cannot be further regularization, provided they fulfill the 3 conditions. So we are bound to follow that, my lord. Whatever we have done, my lord, maybe, my lord, against the law, we cannot repeat it after, my lord, 2006. That's our stand, my lord. That part, my lord, of parity will not come, my lord, in this case.
Why not?
That is our stand, my lord, our understanding, my lord. In fact, that's why I moved
Are
the
you
division bench.
ready to address argument on the principles of parity?
Even in 2019, some workers employees have been regularized. Next year,
On the law, are you ready to address arguments today on the law point?
Next week.
Next week is not possible. If you're not ready today, then after 3 weeks, but you have to come prepared.
Yes,
You have to, this matter, you have to argue for 1 hour at least.
yes.
What has happened here, there is not important. There are diverse situations. The Supreme Court judgment is there. You have to show us how you stay clear of Supreme Court judgment in Umadevi. Otherwise, the petition will be dismissed. Our Devi Learned Counsel for the petition, also our Mr. D. Gogoi Learned SC, Forest Department Assam, and PHE Department Assam, and Mr. B. Gogoi Learned SC, Finance Department, appearing for the official respondents. The core issue herein is as to whether the, by applying the principle of parity, can a writ of mandamus be issued to regularize the service of the petitioner after the coming into effect and after the delivery of the judgment by the Honorable Supreme Court in the case of Umadevi versus State of Karnataka. What is that? You
2006, 4SCC page 1.
let us just see the citation, proper citation. Even though the name of the petitioner was inadvertently left out from the list of departmental candidates whose services were earlier regularized in the year 2005 as per a policy decision of the government of Assam. First of, the learned counsel for the petitioner as well as the respondent have prayed for some time to address arguments on the law point as noticed herein above. Prayer allowed, list this case again after 3 weeks for admission.
Acknowledgement.
Your Lordship, in this matter, the respondents filed their appeal few days back. I have to file a rejoinder, Your Lordship. I need for
Which respondent?
Sole respondent there.
Sole respondent.
I have filed the affidavit, my lord.
I want to file a rejoinder affidavit.
Mr. Chief P. Chaudhary, learned counsel for the petitioner submits that the counter affidavit filed by the respondent 2 days back needs rebuttal and therefore he be granted how much time?
4 weeks time.
4 weeks time to file rejoinder affidavit. Mr. B.K.
29 May.
Das, learned counsel for the respondent, does not have any objection if the prayer is in view of the above. Let this writ petition be listed again on
29th of February,
May 2023 as a fixed item.
Yep.
Lordship, in this case, an amended writ petition has been filed, but the amendment, the portion is not clear from the writ petition. If your Lordship sees the basic structure of the writ petition, your Lordship, the amended one. Quite possibly they have added 14 paragraph. Earlier 14 paragraph has been become 15 paragraph, but it's not apparent from the reading of the thing.
You file your affidavit and
Lordship,
point it
anyway,
out.
then one copy may be given, your Lordship. They've only given one copy for the amended petition. One copy may be given and then we'll file the affidavit in opposition otherwise.
Your Miss R. Begum, learned counsel for the petitioner is present. Mr. C.S. Hazarika, learned government advocates Assam submits that extra copies of the amended writ petitions have not yet been served upon. As a result of which necessary instructions for filing affidavit could not be obtained. Mr. B. Gogoi, Mr. J. Handig, learned HC Revenue Department, Assam, as well as Mr. B. Gogoi, learned Standing Council Finance Department, appearing for the response numbers 1 and 2 respectively, have also prayed for some more time to obtain instruction and file affidavit in the matter. Prayer allowed. List this case again after 4 weeks so as to enable the respondents to file affidavit.
Item 31.
May I please, your Lordship? Lordship, herein the petitioner number 1 and 2 are the junior assistant, your Lordship, under the establishment of DICC Kachar, my Lord. Now, the petitioner aggrieved by the impugned final gradation list, my Lord, which is published in 14/3/2022. Prior to that, one provisional gradation is also there. But your Lordship, our only grievance is that the petitioner and the private respondent number 3 and 4 are selected through the different selection process, my Lord. All the selection process, that is written test, oral, computer test, all are separately conducted, my Lord. And after all, it is a fact that the petitioners and the private respondent are joined the service in the same day, your Lordship. But the selection process are totally different, totally separate, and the mark sheet also published differently, your Lordship. Now, how the seniority and the merit list can be published combinedly, your Lordship, when the selection process are different and separate?
You don't know how, you tell us how.
Your Lordship, on the last occasion, we have filed one reply in affidavit countering their opposition in affidavit, my lord. Here we annex two. There.
Two petitioners are there.
Yes, your lordship.
Both of them are having same claim of seniority.
Yes, your lordship. Because both are selected prior to respond.
But between 1 and 2, who claims seniority above whom?
That is, your lordship, as per mark sheet. Petitioner number 2 will be the senior to petitioner.
Where have you stated that?
Yes,
Where
sir.
is that statement?
No. Actually, our only grievance is that, your lordship.
Your grievance may be whatever. When the court is asking a query, you have to answer it. This is a seniority dispute. Two persons have come. You are saying petitioner number 2 is senior to petitioner number 1.
Yes.
Where is that statement? You have to show us. Otherwise, how do we pass an order? Tomorrow, petitioner number 1 may come against petitioner number 2.
No.
That's why these joint petitions are not maintainable.
Actually, according to them,
Doesn't matter whatever they say. The court is asking you.
No, sir.
You have to answer.
Actually, seniority may be considered as per merit list.
Where is that statement?
Your lordship, they stated in their
Where is your statement? Two petitioners in this case, is it not?
Yes.
Who is senior to whom? Between them, who is senior? Between inter se, the petitioner number 1 and 2, who is senior?
Actually, they are appointed in the same day with the lordship. We are not disputing.
You may not, but I need to know as a judge, who is senior between them?
We didn't state it in our.
Then this repetition cannot. be
Kindly accommodate 1 week time, your lordship. My senior will argue this.
Who is your senior?
Dear lordship, your lordship.
I'm for PL4 now. Right.
What is your response?
My response, my lord, the select list, though there were 2 advertisements, but it is a common select list. As per the common select list, my lord, we were placed in the right seniority positions.
You are placed above them in order of merit.
Yes.
Both of them.
Both. So as per our stand, my lord.
Where is the select list? Let us see.
My lord, in
Where does one find the select list?
my lord, page 9 of my affidavit, my lord. I wrote.
Affidavit by respondent number?
3 and 4, my lord, page 9. The roll numbers are given by the. And individual orders of appointments were issued, my lord, from page 10, my lord. And it should be series, my lord, 0 to 3.
Where is the list? Where is the select?
This we have not been provided, my lord. This is the selection, the roll number selection, my lord.
And according to respondent number 1 and 2, who is senior to whom?
They have filed their affidavits, my lord. In their affidavit.
Are you appearing in this case, Mr. Your name, please?
N. Kalita.
Are you appearing in this
No,
case?
lordship.
You are not appearing.
No.
Then what are you doing here?
Lordship, he's on legs, actually. My senior is on legs.
No,
In
but
code number 6.
you are not appearing in this case. No.
Most probably he wanted to take time.
Huh?
Wanted to take time.
I came for time being, lordship.
Mr.
Ardash, your lordship.
Ardash, the counsel is present on behalf of the petitioner, Mr. PD Nair, and its counsel has appeared for respondent number 3 and 4. When this matter was called up, a prayer for adjournment has been made on behalf of the Learned Standing Council Industries Department. In view of the above, this matter stands adjourned for 2 weeks. You should have said it in the beginning then. Yes.
of life.
May I please your lordship. Lordship, the petition has been filed for release of pensionary benefits, my lord. What has happened, my lord, the petitioner was allowed to go on voluntary retirement, my lord, on 0-11-2012. During the pendency of the writ petition, my lord, the respondent authority has filed an order which is annexed in the additional affidavit, my lord, by which the earlier order by which I was allowed to proceed on voluntary retirement has been cancelled, my lord. A fresh course of
Fresh course
action
of
is
action.
arrest.
Fresh course of action is arrest, madam.
My lord, I may be allowed to withdraw the matter, my lord, with liberty to file a fresh, my lord.
Mr.
R.B. Guha, my lord.
R.B. Goyal, learned counsel for the petitioner submits that during the pendency of this writ petition, the earlier order permitting the petitioner to go on voluntary retirement has been cancelled, and therefore a fresh cause of action has arisen in this matter, which requests to be assailed by filing a proper writ petition. As such, Mr. Gohai seeks leave of this court to withdraw this writ petition with liberty to file afresh. Mr. D. Gogoi, learned standing counsel.
Forest, madam.
Forest Department, Assam. Mr. R.K. Talukdar, learned counsel appearing for the Accountant General, Assam, and Miss A. Talukdar,
Pension.
learned Government Advocate, Assam, appearing for the Director of Pension. Pension, are present and do not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal with liberty as before. Yes.
I love.
Yes.
Please. In this matter, my lord, respondent 8 has filed his affidavit, my lord. Yesterday I received the affidavit. That is not on record, my lord. The date may be fixed, my lord.
Time for respondent.
No.
You want to file rejoinder?
Yes, my lord.
Mr. S.K. Royal, learned counsel for the petitioner submits that a copy of the affidavit in opposition filed by the respondent number 8 has been served upon him only yesterday, and therefore he be granted 2 weeks' time to obtain instruction and file rejoinder. Who is appearing for whom? Mr. J. Hendrik, learned SC Revenue and Disaster Management, Assam, is present on behalf of respondent number 1. Ms. A. Talukdar, learned Government Advocate, Assam, has appeared for respondent numbers 2 to 6. And what about 7?
7 to Nassau.
Whereas Mr. D. Bora, learned counsel, has appeared for the respondent number 8. In view of the prayer made by the petitioner's counsel, this matter stands adjourned for 2 weeks. The registry to tag the affidavit filed by the respondent number 8 with the record of this case and list the matter again after 3 weeks.
Date may be fixed, your lordship.
After 3 weeks.
3 weeks.
Of life.
Item 34.
My lord, in this case, respondent number 2 has filed counter affidavit, my lord. I want to file rejoinder, my lord, in this case, my lord. And this time.
My lord, we have filed the affidavit in opposition. My lord, this is a very small matter. Can we dispose of today also? Because they have come before this court challenging the representation of the workmen in the learned labor court at the stage of cross-examination in the execution case. There was a reference case, then they lost in the reference case, they appeared in the High Court, they challenged the order in the High Court. There was a contempt petition also, nowhere it was challenged. But when the execution case was lodged, in the stage of cross-examination, they challenged the representation of the workman, stating that the person representing him is not a member of any trade union. So we have submitted the requisite documents to show that he is a member of the trade union, of a registered trade union.
So the proceeding has stayed there.
Yes, there is a stay, my lord.
And you filed a counter affidavit yesterday.
No, my lord. We filed it in March itself, last week of March.
My lord, the petition they have filed, my lord, that is not execution proceeding, that is under 33(2)(c), my lord. And
So what is the problem if the workman is given a legal?
My lord, what happened?
You want to crush him?
My lord, the section 36 specifically made provision who can represent a workman. And my lord, the person who is representing the workman, my lord, he is not belongs to any category of that, my lord, provisions, my lord. And that is why we raised my lord objection in the case, my lord, when he wanted to cross-examine my lord management. And then my lord court, my lord heard the matters, learned tribunal below, and my lord passed order allowing him to.
Where is the order?
That is my lord page
Page,
100, my lord,
page 100.
my lord. Annexure 13, my lord. Order dated 19/2020. Married, my lord.
Acha, you have a lawyer,
My
but the workman cannot engage.
No, my
anyone.
lord, he can represent by any authorized person. Here, my lord, specifically mentioned in the order, my
My
lord,
lord,
we
the-
have not objecting for representation, my lord. But, my lord, by the person provided by section 36. Or by lawyer also, we did not make any, my lord, objection. But the person can be represented by any person authorized under section 36, my lord. That is our humble prayer. And our contention is that he is not belongs to.
36 of Industrial
Yes.
Dispute Act.
My lord, we have in our affidavit in opposition, we have satisfied that A, he is a member of the Indian National Trade Union Congress, which is a registered organization.
Then we'll have to give him at least 10 days time to find
My
out.
lord,
My lord, the
We'll fix
date
a
may
date.
be fixed.
Well,
My
my
lord.
lord.
When do you want it?
My lord, 12th of May, if possible.
12th of May, all right, all right. Take down Mr. UK Das, Learned Counsel for the petitioner is present and prays for 10 days time to file rejoinder responding to the affidavit in opposition filed by the respond number
2.
two. Full stop. Miss
As does.
S. Das, Learned Counsel for the respond number 2 has expressed urgency in the matter by submitting that the proceedings before the learned industrial tribunal has been stalled due to pendency of this read petition. Mr. H. Chakraborty, Learned Government Advocate Assam is present on behalf of respond number 1. After hearing the submissions of Learned Counsel for both the side and as requested by them, his read petition is directed to be listed again on 12th of May 2023 as a fixed item. Rejoinder, if any, be filed by the petitioner on or before 10th of May 2023.
My lord,
by
may I
serving-
pray, I also want to file an additional affidavit to bring on record the, because there's a condition that he has to be similarly placed, the trade union has to conduct similar union work. So I want to bring that on
We'll
record.
see what happens. You see, now if you do it, then it'll go further beyond.
Okay.
On or before 10th by serving advance copy upon the counsel for the respond number 2.
Much
Till then, my lord, interim may continue.
Interim order part earlier to continue till 12/5/2023.
Deeply obliged.
much.
May it please your lordship. The matter pertains to compassion appointment, your lordship.
Here I
no-
am seeking some time to file the affidavit, your lordship. Instructions have not been received, your lordship.
Heard
Your
miss.
lordship, the matter has been, it's an old matter, your lordship.
No, it's a 2023 case.
No, in the sense that your lordship, the petitioner had. seeked
That's
for
the problem
compassion.
here. That is the problem. Matter is old, but you have come very new.
Yes, your lordship.
So your miss,
Miss Sidas, your lordship.
heard Miss Sida, Learned Counsel for the petitioner, also heard Mr. C.S. Hazarika, Learned Government Advocate Assam, who submits that instructions, as called for, are still awaited, and therefore he be granted 4 weeks further time to obtain instruction. Prayer allowed, let this matter be listed again after 4 weeks.
Much obliged. your lordship.
Lordship, respect earlier order, no affidavit has been come, your lordship, from the.
Lordship, only changes are given, lordship, and that during this holiday, lordship.
You. Is it
Lordship,
you?
may.
You want to file affidavit? You want to file affidavit?
Lordship,
You want to file affidavit?
yes, lordship.
How
The
much time?
Instruction, lordship,
All right, how much time you want?
10 days, lordship, only 10 days.
2 weeks. Heard Mr. L. Mohan, Learned Counsel for the petitioner. Also heard Mr. Talukdar, Learned Government Advocate Assam, representing the respond numbers 1 and 3, who submit that she has received instructions and be granted 2 weeks time to place the same on record in the form of an affidavit. In view of the prayer made by the Learned Government Advocate Assam, let this read petition be listed again after 3 weeks as a fixed item. Affidavit on behalf of the official respondents be placed on record within 2 weeks by serving advance copy upon the petitioner's signature.
Deeply obliged, lordship.
May I please, your lordship, so prior to making any submission, my lord, here, Miss R.R. Sekia is the conducting counsel, my lord. Today, her father is seriously ill, my lord. She have to leave.
Mr. Sharma,
My lord.
if you have any request,
my lord.
You please make it straight away. I'm not asking for explanation who is sick, who's,
I may be allowed to.
yes,
represent.
you want to argue.
Yes, my lord. Here in this case, my lord, the government advocate on the last occasion, my lord, learned government advocate on the last occasion has paid time for to obtain instruction, my lord. My lord, whether the instruction.
No, instruction has not been received, Lordship. Some time will be required, Lordship.
We are in the first quarter of 2023. I have to give him one more opportunity. Heard Mr. M.K. Sharma, learned counsel, who has appeared for the petitioner. Also heard Mr. A. Chakravarti, learned government advocate Assam, who submits that instructions as called for have not yet been received, and therefore he be granted another 3 weeks time to obtain instruction. Prayer allowed. Let this matter be listed again after 4 weeks as a fixed item for admission.
Please, my lord, because the responding government was directed to obtain instruction in this matter.
Lordship, the records were sought to be
Records
produced,
were called
Lordship.
for.
Some more time is required.
Records were
Mr.
placed.
S. Shandila, learned counsel, is present for the petitioner. Miss A. Devi.
M. Devi,
Devi.
appearing on behalf of Mr. Dina. Standing counsel
That-
PWD.
That's all right, learned counsel appearing for the respondent. Only one respondent here? How many respondents?
So there are 8 respondents.
Respondent PWD Assam. 6 further 4 weeks time.
Lordship.
Obtain instruction and file affidavit. Prayer allowed. Let the matter be listed accordingly.
Obliged, Lordship.
May it please your lordship. Order dated 5/4/2023 may kindly be seen. Pursuant to that order, respondent number 6 supposed to file an affidavit.
Lordship, I pray for further 1 week's time, Lordship. Because of my personal difficulty, I could not file it today, Lordship, next week.
I heard Mr. R. Islam, learned counsel for the petitioner. Also heard Ms. Ms. M. Bodole, learned counsel for the respondent number 6, who submits that notwithstanding the order dated 5/4/2023, due to some personal difficulty faced by her, the affidavit could not be brought on record. The learned counsel, however, 10 days time to place the affidavit on record. Ms. A. Talukdar, learned government advocate Assam, is present on behalf of respondent numbers 1.
A date may kindly be fixed, lordship. We are
In view of the prayer made by learned counsel for the respondent number 6, let this petition be listed again on 17/5/2023. The affidavit on behalf of the respondent number 6 shall positively be filed within 10th of May 2023 by serving advance copy upon the petitioner's counsel.
Obliged.
None appears for the petitioner on call. List this case again on Friday. What is the date of Friday?
For orders, item 39.
Here I'm appearing for respondent number 2, Lordship. Lordship, I am seeking 2 weeks time to get an update regarding the present status, my lords, because the case of the petitioner.
Present, sir, this is a contempt case of 2019.
Yes, my lords, here what happened was.
Call him, who is the person?
No, Lordship may just say, Lordship, the case of the petitioner was, the direction was to consider the case of the petitioner for promotion, my lords. Here his case was considered and then he was entitled to the promotion, my lords, but a DPC was ordered to be formed, my lords. The formation took a little bit of time, my lords, because of it, and after the DPC was formed, my lords, he was entitled, like, there was a finding that he's entitled to a promotion, my lords, but by then he retired. Now the officers are trying to figure out a way how they can accommodate the petitioner to a higher post, my lords, because as per law, there was certain complications that he was not entitled, my lords. He was a welder, but after the committee was formed, then special consideration was given, my lords. Now they're just trying to find out a way how to accommodate the petitioner, my lords. Lordship, I'm seeking
Mr. N.J. Khatrunia, learned counsel, is present on behalf of the petitioner. Mr. A. Cholia, learned counsel for the respondent numbers 1 and 2.
Lordship,
submits that this is not a case of willful disobedience of the order of this court, but steps are being taken.
Yes, Lordship.
To figure out ways and means how to give
to
relief to
accommodate
the petitioner by meeting the requirement of law. Full stop. As such, Mr. Chalia prays for and is granted another
2 weeks.
2 weeks time to obtain updated
Lordship,
instruction.
Lordship.
Will
Oblige, Lordship.
List the case accordingly.
Oblige.
And what is this?
But the direction is to place the case before the SLC. It was placed, SLC minorities with me, Malad, and this speaking order was passed. It was rejected by the SLC.
Now appears for the petitioner on call, Mr. D. Nath, learned counsel appearing for the respondent submits that as per the order of this court, the case of the petitioner was placed before the SLC, which had rejected his prayer. As such, the order of this court has been complied with. In support of his above argument, Mr. Nath has produced a copy of the
Minutes of the SLC.
minutes of the SLC meeting held on 3/10/2019 at 2:30 PM,
And the speaking order is last page.
as well as the speaking order dated 22/10/2019, issued by the competent authority. I peruse the same. In view of the above, nothing survives for consideration in this contempt case. By retaining a copy of the minutes of meeting dated 3/10/2019, as well as the subsequent speaking order dated 22/10/2019, this matter stands closed. Yes. That's it. We'll reassemble at
My lord,
day after tomorrow, Mr. Chakraborty. We have passed now, and the other side is also not there. Inform her.
my
Day
lord,
after tomorrow. You are there?
day after
Yeah.
tomorrow, I'll not be here, my lord.
Then
Can it be
one-
on second?
all right.
The only thing, my lord, we are not pressing relief already granted. And we are not pressing this. There is no live issue.
No, that's correct. But once the court is.
My lord, I was on
We are
legs.
We are on online live streaming nowadays.
My lord.
We have to follow this.
Second, my lord.
Second May. Second May.
Item 42.
As per office note, lordship, service is awaited, lordship. Perhaps the respondent are present, these incumbent are no more in the present post, lordship. I may be allowed to file an impleadment petition to impleading the present incumbent.
Mr. A.B.T. Hogg, learned counsel for the petitioner submits that although service report is still awaited on the respondents, yet as per instructions received by him, the present incumbents who are responsible for implementation of this court's order is required to be implemented by filing an impleadment petition. Therefore, full stop. Therefore, he will be granted 3 weeks time to take necessary steps. They are allowed. Let this matter be listed after the application for impleadment is filed.
Item 44.
Your lordship, may kindly give us some time as my senior is on legs. Lordship, we are appearing, I am appearing for cake work, additional advocate general. He said affidavit is ready to send for vetting. Only 2 weeks time for granted.
Yes, what do you say, Mr. Kaur?
Well, let us have it on subject to your lordship on 9th of May.
9th of May, how much time you need for filing a?
2 weeks.
2 weeks time.
10th of May. Heard Mr. B.D. Kaur and Senior Counsel appearing for the writ petition. Also heard Ms.
N. Bora.
N. Bora, learned SC, PNRD Department, also to submit that affidavit on behalf of the official respondents is ready and has been sent for vetting. Therefore, 2 weeks time be granted to take the affidavit on record. In view of the above, in view of the request made by the learned Department Council registered to this case again on 10/5/2023 as a fixed item.
Yes.
Item 45.
May I please your lordship, my lord, in this matter, the standing council PNRD was asked to obtain instruction, my lord, by last order. my lord.
The order, where is the order of the?
Order is at page 10, my lord. And operative portion starts at page 12, my lord, paragraph 8, my lord. The petitioner was terminated from service, my lord. And thereafter, annexer B, my lord, the petitioner filed detailed representation at annexer 14, my lord, annexer B, page 14, my lord.
No, no, representation for consideration of his case for what?
For the post of Gram Panchayat coordinator. And it is observed that if there is a necessity, my lord, it is that the state termination shall not come in the way for fresh consideration of the case of the petitioner in the department, if and when the department is of the view that service of similar nature are required. So, my lord, there is another advertisement, annexer C, which shows that there is requirement, my lord, in the post of Gram Panchayat coordinator, my lord. So this honorable court passed a direction to consider the case of the petitioner for fresh engagement if requirement is there. And the advertisement shows that the requirement is there, my
It
lord.
cannot be done. If there is an advertisement issued, how the person can file a representation and be recruited?
Because in terms of the order passed by this honorable
But
court,
that
my
order,
lord.
how is it? It will violate the other orders of the Supreme Court. It will violate the orders of the Supreme Court.
My lord,
Mr. Bora, please understand.
yes, my lord.
It will help you in some other case.
Yes, my lord, I
This
understand.
case will pass our order.
Yes, my lord.
But if you know the law, it will
Yes,
help
madam.
you. In every public office,
Yes,
public
madam.
employment,
Yes, my lord.
what is the procedure to be followed? That has been by now well firmly entrenched.
Yes, my lord.
Number of judgments of the Supreme Court.
Yes, my lord.
There has to be a transparent process, advertisement has to be issued.
Yes, my lord.
Parties will have to be subjected
Yes,
to
madam.
a selection process,
Yes, my lord.
right?
Yes, my lord.
Now, you are coming alleging willful violation of a court's order.
Yes, my
What
lord.
is the order? His termination has not been interfered with,
Yes, my lord.
but the learned judge says if there is any vacancy arising in future
Yes, my lord.
and the authorities are of the view that similar persons are required to be recruited,
Yes, my lord.
then he will submit
Similar person, similar nature of
similar
the.
nature of work.
Yes,
Then he can file a representation,
yes, my lord.
which will be considered.
Yes, that.
Show me by under which law it can be done.
My lord, in terms of this order passed by this honorable court, we have filed a representation for consideration of our
But
representation.
implementing this order would amount to violating Supreme Court's direction.
My lord, that.
That you can't help it.
Because if the, because my lord, petitioner initially challenged his termination order. So after deliberation, my lord, it was before the court,
No, no,
my
I have
lord.
understood. You see, contempt matter would lie when there is a willful and deliberate violation
Yes, my
of
lord.
the court order, is it not?
Yes, my lord.
The order of the court should be deliberately violated. If this order is to be implemented, it will violate the Supreme Court order. They will be in contempt of Supreme Court.
But this order will be also violated, my lord, passed by this honorable court, my lord.
Between contempt of Supreme Court and contempt of High Court,
Yes. my
what
lord.
is to be chosen?
Because we were happy with this order. Otherwise, my lord, because we were against the order of termination, my lord, because the termination order was, in fact, that termination order was without any notice, my lord.
So therefore, you should have got a interference with the order of termination.
But that was not
This is
granted.
a case where you should file an appeal. You have not done it, what can be done? We will go by the law. Show me the law which permits this.
My
I
lord,
will haul them up.
my lord, as a layman,
No,
we
you
are
can't
only
have- you are
going,
not layman.
we are going by the,
No.
by this order only, my lord. By the order of this honorable court. my
Just
lord.
because they are unable to argue these things,
Yes, my lord.
the court will have to have its views on what is happening. In a process of recruitment where advertisement is issued,
Yes, my lord.
how can somebody be recruited based on a representation? Show me that law.
I am only on the.
Then why have we accepted this order?
My lord, this honorable court has passed the order. We
That
have.
order goes against you. You challenge the order of termination.
Yes, my lord.
That was not interfered with.
Not
That's
interfered.
the end of the matter.
But the
You didn't
direction,
get any relief.
but the direction, as per the direction, we have filed representation, my lord.
That representation cannot be considered.
But as per this
The
order.
only
that-
relief you would have got is, if at all,
Yes.
is interference with the order of termination.
Yes, my lord.
That tail is neither here nor there. It cannot
Yes,
be implemented. And learned judges pass this order, maybe you have asked for it, we don't know.
No, my lord.
But the question,
Because in a similar repetition is another.
I am only on one point.
Yes, my lord.
You tell me how this order can be implemented without violating the Supreme Court judgment. Show me that.
My lord, I am not going to the Supreme Court order. I am just with the order passed by this honorable court, my lord, because this honorable court directed me to file a representation. So I have filed it, my lord. That has to be considered, my lord.
That cannot be considered. So there is no violation. That cannot be considered. That
If
cannot
that
be.
is not considered, then that will be a violation of the order passed by this
All
honorable
right,
court.
we'll
my
make
lord.
it clear. Heard Mr. D.B. Vora, learned counsel for the petitioner, also heard Ms.
And
N.
for-
Vora, learned counsel appearing for the respondent.
Respondent number 1 and 2, Lordship, petition is not available with us till now.
Respondent number 1 and 2, alleging willful disobedience of the order dated 17/9/2021, passed by this court in WPC number 2668 of the 2021. This contempt case is filed. First up. It appears that the challenge made by the petitioner to his order of termination from service was not entertained by this court. However, while disposing the writ petition by order dated 17/9/2021, the learned judge had permitted the petitioner to file a representation with a direction upon the authorities to consider the same as and when the department is of the view that services of similar nature are required to be engaged in
Petitioner.
future in any scheme. Full stop. The basis of the petitioner approaching this court by filing the contempt case is that the departmental authorities have issued advertisement notice for recruitment of similar nature of recruitment of candidates for filling up similar nature of post as held by the petitioner, and hence by failing to consider the representation submitted by the petitioner, the authorities have committed willful disobedience and thereby contempt of this court. Full stop. Mr. Bora would, however, not answer the query of this court as to how, in a recruitment process based on advertisement notice, merely on the basis of representation of a candidate, order of appointment can be issued in his or her favor, since such a recourse would evidently run counter to the law laid down by the Honorable Supreme Court of India in a number of decisions. First up, the learned counsel for the respondent has also remained silent when the question was posed by this court. Under the circumstances, this court is left with no other option but to adjourn the matter for 4 weeks.
Oblige, my lord. May I please the lordship?
Yes.
My lord, in this matter, the order is at page 10, my lord. My lord, the relevant paragraph are page 12. My lord, there are two wives of the petitioner, my lord. Paragraph 12, page 12, paragraph 5, my lord.
This is
Relevant.
also a contempt case, right?
Yes, my lord.
Where is the order?
Page 10, my lord. The relevant portion at page 12, my lord. From paragraph 5, my lord.
So what is to be done here? If this happens, that is to be done, that happens, this is to be done.
My
So-
lord, this honorable court directed that they will file representation before the SP and SP will give a hearing to both the petitioner and thereafter they will decide, my lord, to whom the pension has to be paid.
So SP will take a decision on the interpretation of the rules.
Yes, my lord. And after hearing the parties. Now, my lord, because my lord, the first wife, she has been divorced by the husband, and her name has been struck off from the service roll. That has been admitted by the respondent authorities during the writ proceeding, my lord, by filing a affidavit. So she is not at all entitled. So that aspect was not considered. No opportunity of hearing was afforded, and entire retirement benefits have been paid to that first wife, my lord.
So don't you think it was for the court to decide who is entitled rather than asking the superintendent of police to consider representation and decide who is entitled?
Yes, my lord.
Then
That is true.
Why have you agreed for this order? What is the contempt here now?
Contempt is that I was not afforded any opportunity. I was not asked to, although I went there to submit my documents, my lord. First wife, my lord, apparently her name was struck off the affidavit of the respondent authorities.
So Mr. Bora, I am only on one thing.
Yes, my lord.
Which of the two wives under these rules
Yes, my lord.
would be entitled to family pension?
Yes, my lord.
Is it a matter the SP is to decide this, or is it a matter for the court to decide?
This court could have decided, my lord.
Has that decision been done?
No, my lord. But court directed both the petitioners, my lord, to approach the SP, and SP was directed to give.
No, don't agree with what I'm asking. You are free to give a different view.
My lord,
I'm trying to figure out what is.
no, at that point of time, my lord, both the wives were agreeable to this order, and they filed a joint representation once. But later on, the first wife, whose name was struck off from the service roll, she separately approached the SP.
That's what I'm saying. Just by agreement, the law cannot be rewritten.
Yes, my lord.
See, in a court proceeding, if everybody agrees to an order and then it comes for contempt, can you rewrite the law?
No. Yes, my lord.
Everybody has a duty to put things in the right course.
Yes, my lord.
So how is this court going to implement these kind of orders in contempt case?
Yes, my lord. The court could have decided, my lord, because that wife, my lord, her name has been struck off. That was evident from the affidavit of the respondents, my lord. And in fact, my lord, this matter should have come for motion, my lord, first day, today, my lord. But it has wrongly come in the coming order, my lord.
If you want to do some good to your client, why don't you prefer, it's not for me to give a legal advice, why don't you prefer a review and request the court to decide the claim? SP cannot go on deciding these matters. What will happen? He will sit over the matter and take a terrible decision after contempt gets over his head, then you again come back and you file another writ petition. That is what is happening.
Yes, my lord.
30 to 40% of the writ petitions today are absolute junk. It is the third round, second round, fourth round, fifth round of the same dispute.
Yes, my lord.
This is what is happening.
Yes, my lord.
And see the impact of this in the institution.
That alternative.
Genuine
also-
cases, people who are waiting, struggling to get their pensions,
Yes, my
their
lord.
termination, dismissal orders, and those matters we don't have time to hear.
Yes, my lord. That alternative also we can avail, but here, my lord, notice may be issued at this stage, my lord.
No notice, then you argue and satisfy me that there is some order which is to be complied with here. I'm not open to issuing notice here. Contempt is a serious business.
Yes, my lord.
What was required to be done? You show me.
My lord, paragraph 5 says that it is stated that the service records of the deceased so-and-so records the name of Jerina Ahmed as his wife. In view of the variance in the family claim raised before the court, we require both the petitioner number 1 and petitioner number 2 to approach the superintendent of police West Karbi Anglong Hamren and to produce any relevant material that they may desire to substantiate their claim as to who between them is the eldest surviving wife of the deceased. It is also stated that the second wife, that is Zarina Ahmed, had neither filed any application nor made any claim for family pension till date. Although in the order of seniority, she may be the second wife of the deceased. Then my lord, paragraph 6. Accordingly, upon appearance of the petitioner number 1 and petitioner number 2, the superintendent of police West Karbi Anglong Hamren shall determine as to who between the petitioner number 1 and the petitioner number 2 would be the eldest surviving wife of the deceased. Because petitioner number 1, she has been divorced, her name has been struck off from the service.
That's right. That's what I'm asking. This is a legal issue.
Petitioner number 2 is
Between 1 and 2, who is entitled is a legal determination.
yes, my lord.
That is done by the courts. Now here the superintendent of police will have to do it.
Yes, my lord.
That's correct. Now
That
you
was the-
proceed. You
that was the direction, my
You
lord.
proceed further. Let us see.
And accordingly pay the family pension as indicated above as provided under Assam so. So that this honorable court directed the SP to determine who is the eldest surviving wife.
And therefore will be entitled to receive pension.
Yes, my lord.
Yes.
That was the direction.
Then proceed.
Then, my lord, in the event the second wife of the deceased Zarina Ahmed approaches, because there was another question of second wife, but the second wife did not come, my lord. So this paragraph 7 is regarding the second wife. Second wife already got married to some other
Please read
person.
the paragraph.
Zarina Ahmed approaches the superintendent of police and makes a claim. The superintendent of police shall give a personal hearing to all the 3 wives of the deceased and arrive at his decision. If the second wife, that is Zarina Ahmed, does not come forward, the decision of paying the family pension of the deceased shall be confined between the present 2 petitioners. And if the second wife appears at a future date, the superintendent of police may give a renewed hearing to all the 3 wives and arrive at his decision. So now paragraph 7 will not be applicable because the second wife has not come forward. So I am on paragraph 6, my lord.
Very strong case you have heard. Mr. D.P. Bora, learned counsel for the petitioner, peruse the statements made in the contempt case. This petition has been filed alleging willful disobedience of the order dated so-and-so passed by the learned single judge in WPC number so-and-so. Issue notice determinable in 12 weeks. Petitioner to take steps for service of notice upon the respondent. Yes.
Hello, time. Oblige, my lord.
Consider yourself lucky that notice has been issued.
Yes, my lord.
I don't want to say anything more, though I have much to say. Yes.
Lordship, contempt matter, Lordship. Order is at page 10, relevant parties at page 103, Lordship. Escort being matters, Lordship, number of cases are pending before the annual court, Lordship. Similar matter, Lordship, these were, Lordship, terminated employees, Lordship. Lordship, earlier also I had filed a contempt case, Lordship, but the honorable court state that you have arrayed this response, they should not be arrayed. So you struck off their names, Lordship. So I had to, it was not allowed, Lordship, not willing to allow, court was not willing
Now,
to allow.
what is this? This is a contempt case.
Lordship, I was,
Coming up for the first time.
no, Lordship, second time, Lordship. I have to withdraw the first one, Lordship.
So that's right. This case is coming up.
This is for the first time, Lordship.
What is the violation here?
Lordship, Lordship may come to page, Lordship, 103.
Correct, yes.
Similar cases are there, Lordship. Lordship may start from serial number 25, Lordship, in italics. In view of the reason, that is a part of another order, Lordship. In view of the reason stated about this court finds that the impugned orders dated so and so, terminating the services of 265 numbers of employees is arbitrary and is accordingly set aside. The decision of the board of the directors dated so and so is also set aside. If the respondent decide to terminate the petitioner services, they will have to comply with section 25F of the Act. The import of the direction to comply with section 25F of the Act requires the petitioners to be reinstated back into service, which should be done by the respondents at the earliest.
So it is allowed in terms of earlier order by
Lordship,
setting aside.
Lordship,
There is no direction to reinstate you.
Lordship, there was a direction to
Where
reinstate.
is the direction here?
Lordship, earlier order to petition.
Your grievances, they have not been
Lordship,
reinstated, right?
Lordship.
Where is the direction to reinstate you?
Lordship, there was a direction to Lordship that was set aside, Lordship, the termination orders.
Where is the
That is-
direction to reinstate you?
Lordship, that is also there, Lordship.
Where is it?
Lordship. Lordship may come to page 90, Lordship.
Hmm. Page
Subsequent
90.
part, Lordship, serial
No,
number
no,
26,
Mr.
Lordship.
Bhagavathi.
It is made clear that the salary of 3 months paid.
We are in the order dated 29/4/2022.
Lordship,
You are filing this contempt case on the ground that this order has been violated,
Lordship,
right?
Lordship,
In this order, the termination of your client's services have been set aside
Lordship,
by relying on a previous decision,
Lordship.
but there is no direction to reinstate you. Is that correct or
Lordship,
not?
automatically we come, Lordship. Termination orders go, if the termination orders goes, Lordship, we are automatically reinstated, Lordship.
But by when? By how many days?
Lordship, once that goes, Lordship, we are automatically, the termination order goes means that dated order, we are automatically in, Lordship.
Again, 12 weeks. Not convinced these are matters of contempt. But this is how
Okay,
the
similar
system-
matters are pending, Lordship is taking up those matters also, Lordship. Last week also, Lordship took up those matters.
What, similar contempt?
Lordship, similar contempt matters, Lordship. I can give the numbers, Lordship.
Mr. M. Bhagavathi, then so and so alleging willful issue notice returnable in 8 weeks. Petitioner to take steps for service of notice upon the respondents.
Much older.
Item 48.
Wait, Lordships. Lordships, the judgment of this honorable court starts at page 21. The effective portion is at page 23. The order, Lordships, not the judgment, I apologize. The direction was to verify whether the husband of the petitioner has suffered a disability or not. And if such disability was found, there was a specific direction to act as per the mandate of section 24 of the Rights of Persons with Disabilities Act.
Yes.
Thereafter, Lordship, they conducted a complete survey of my husband's thing. A medical examination was conducted. They issued a medical certificate saying that I'm 100% disabled, mental as well as physical, both. And the Lordship will find that at page 35, annexed to G, they have now come up with a new plea saying that I should be directed as advised by the government of Assam in the administrative department. The services of you are directed to act as per rule 82 of the Assam Services Pension Rules 1969. I'm reading at page 35 annexed to G, Lordships. For sanction of invalid pension to Sri Kamal Das. Now, there's a specific direction by this honorable court. Lordship. The entire matter was taken up. The government council was heard in the matter. And it was only thereafter that the honorable court, although it was at the motion stage, but this honorable court was of the opinion that it is correct that the Rights of the Person with Disabilities Act mandate will have to be followed. And there was a specific direction. In fact, I have also challenged the.
No, the operative part is in para 8 of the.
Yes, Your
order,
Lordship.
is it?
Accordingly, the Secretary of Government of Assam in the PHED shall examine as to whether the husband of the petitioner, due to an accident he had suffered on so-and-so, had acquired a disability which prevents him from attending the duties in the required manner. If upon such examination, the Secretary finds that the husband of the petitioner had in fact acquired a disability, appropriate orders be passed regarding the entitlement of the husband of the petitioner of his service conditions, meaning thereby his salary, etc., and act as per the provisions of section 24 of the Act of 2016. To enable the Secretary to do the needful, the petitioner may approach the Secretary with the necessary documents, etc., etc. Lordship, the only liberty which was granted to the government was to check, verify whether I have actually suffered the disability or not. Having verified that, they cannot now fall back upon Rule 82 of the Assam Pension Service Rules, 1969. They are stopped from doing that, especially in view of the fact that, Lordship, if there is a conflict between a special provision and a general provision, the special provision will have to.
What does 20 subsection 4 say?
Lordships, I'll just take your Lordships to that. Have we quoted in the petition? Lordships,
24 was quoted in the order, if I'm not mistaken. I'll take your lordships to 24. Rights of Persons with Disabilities Act 2016.
Yes.
Non-discrimination in employment. That is the heading of section 20, your lordships. Clause 4. At page 14, your lordships will get it, of the book. Clause 4. No government establishment shall dispense with or reduce in rank an employee who acquires a disability during his or her service, provided that if an employee after acquiring disability is not suitable for the post he was holding, shall be shifted to some other post with the same pay scale and service benefits. Provided further that if it is not possible to adjust the employee against any post, he may be kept on a supernumerary post until a suitable post is available or he attains the age of superannuation, whichever is earlier. Now, it was on this ground that we had filed the writ petition before this honorable court, seeking the arrear salaries and wages of the husband, the petitioner's husband. After hearing the parties and hearing also the learned counsel for the respondents, this honorable court issued this particular direction, your lordships. So my humble submission before your lordships is that the only liberty which was granted to them was that they could have verified my disability and then acted as per the mandate of the Act of 2016, which they have not now done. I may also point it out to you, lordships, that I have also challenged the validity of this order, which has now been issued at page 35 by way of filing a fresh writ petition. And that was also listed today before Honorable Justice D. Barua, and a notice of motion has been issued in the matter, your lordships.
All right. Can you give the number of that case?
Yes, your lordships. It was WPC number 2176 of 2023.
Take down heard Miss R.S. Chaudhary, Learned Counsel for the petitioner alleging willful disobedience of the order dated 9/12/2022 passed by the single judge in WPC number 744 of 2022. This petition has been filed. I have perused the statements made in the content petition. Issue notice returnable in 6 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with AD within a week from today. On the request of learned counsel for the petitioner, registry to list this case along with WPC number 2176/2023, which is stated to be connected with this.
Worship, there was one small further prayer. In the earlier round of litigation in the writ petition, I had not made the secretary of the ART PPG. There's a department called the Administrative Reforms and Training, Pensions and Public Grievance Department. Now that was naturally not a party respondent in my writ petition. However, in the order which has now been passed, they are making a specific statement that it is as per the directions of that particular authority that this action has been taken, that invalid pension has been sanctioned. I have claimed, I have made a prayer before this honorable court that if possible, that gentleman should also be allowed to be made a party respondent, subject to your lordship's thing.
We'll see.
Perhaps
First, let them
that thing could be left open, your lordship, that prayer.
That we'll see.
We'll
Let
see,
the
lordships.
parties appear.
Lordships.
Yes,
I'm deeply obliged.
yes.
Supplementary list for orders, that is 158.
Pursuant to lordship's order dated 29th of March, the affidavit of the circle officer has been filed, my lord. We have filed the affidavit today, my lord.
Have you received copies of the affidavit?
I have received
You have
a copy
received-
today, my lord.
Item 56, my lord, not similar, my lord, but why, I don't understand why it is tagged, another two items, my lord.
In
Your issues are
Just
so
a minute,
identical.
just a
it
minute.
is-
Lord,
Please don't. The
Lord-
affidavit has been filed in which case?
in item 56, my lord. WPC 11008 of 2023. There is an order dated 29th of March.
Who is for the petitioner in item 56?
I am for the petitioner.
You have received a copy.
Yes, my lord.
Okay, and you are appearing for?
I'm 57, 58. For respondent number 6,
Is it connected with 56?
it has been connected.
Why these cases have been clubbed together?
My lord, in item
Both the
56, my lord.
selection regarding my lord, selection of my lord. So that is why it was connected, though it is not interconnected.
Not for the same village, not for the same village. Process is same.
And issues are also this. my lord,
57
different.
and 58 may be taken.
All right, then you go through the affidavit and you want to file any rejoinder?
No, this affidavit is not an affidavit in opposition. Malad. In fact, during pendency of the status quo order, he was not, don't have the knowledge of the status quo order, and he passed an order which is Malad, in fact in violates the order of the honorable
So
court.
whatever,
That
he
is why
wants to
the-
file a rejoinder.
Lordship, Malad, it's a Lordship. Malad, in the main case, affidavit in opposition is not yet filed. We'll file that affidavit in opposition. Otherwise,
Heard
here-
Mr.
his
Ayat
conduct-
Tekka, learned counsel for the writ petitioner is in item 56. Also heard Mr.
Yeah, you
So and so learned counsel for the writ petitioners in item.
I am for the respondent, I have filed stay vacation petition in 56.
For the respondent in item number 56. Who is for the petitioner in item 57 and 58?
I am for the petition.
Acha, you are for petitioner in all the cases.
All the cases.
The petitioner is in item 56.
57, 58, I have filed an application for vacating.
Also heard so and so appearing for the private respondent in item 56, who submits that an application for vacating the stay order filed on behalf of his client is pending disposal. Similar is the submission of Mr. B.C. Das, learned senior counsel appearing for the private respondents in item 57 and 58. Post up. Mr. D. Nath, learned senior government advocate Assam submits that in terms of the order dated 29/3/2023 passed by this court in these proceedings, the circle officer of Bagbor Revenue Circle has filed an affidavit yesterday,
Today, Malad.
today,
We filed today.
filed an affidavit today, which is not on record. First, Mr. Saikia also submits that he be granted a week's time to seek instruction and file rejoinder if necessary. Although urgency has been expressed in these matters by learned counsel for the private respondents, yet in view of the above developments, registry is directed to list these matters again on 8th of May 2023 as fixed items for orders. Rejoinder, if any, be filed in the meantime by the petitioner's counsel. The IAs will be listed. IAs will be, all the interlocutory applications will be taken up for consideration on the next date.
In the meantime, an affidavit in opposition will file.
In the meantime, the other respondents may file counter affidavit.
Lots.
Interim order passed earlier to continue till 8/5/2020.
Lordship.
May I please, your lordship. Lordship, kindly adjourn the matter for today, my lord. My senior, Mr. B. Kosiki, out of station, my lord. I have informed the other side also, my lord, the university, my lord.
Yes, my lord.
On the prayer of learned counsel for the petitioner made with the consent of the other side, hearing of these matters stand adjourned for 4 weeks. List accordingly.
Deeply obliged, my lord.
There was item 53, my lord. It has not been called. We were there, my lord. In the first of also we were there, my lord.
First, how we are here.
Item 53, my lord.
You called it serially. You called it serially. Actually, it seems this matter was called earlier, but somehow.
Anyway.
We'll have it day after tomorrow then.
My lord, I have some difficulties, my lord. I was living for Kolkata, my lord, regarding some medical treatment, my lord.
When do you want it?
My lord, can it be on next Friday, my lord?
No, Friday to the program because I will go under eye side operation, but it is up 10th. 10th, after 10th.
So 10th, make it 10th.
But
So it has been posted after 2 weeks.
PRD, the commissioner is not coming. That is the problem. It is a pension matter, madam. There is order of the High Court. To
On 10th, could go.
10th.
Just a minute. This is not correct. Call all matters serially. No. This is wrong. Whoever has given the instruction, tell him that he is wrong. He should come and meet me. Because the lawyers will not be aware. No? If item 53, if you call after 15, they will not be present. No, this is wrong. It has to go by serially. The council will not know. He will not come for item 53 at 11 o'clock. This is wrong. That is why when seriality is given, it has to go.
Should we take fresh steps upon the commissioner who is not attending the court in spite of the fact that he received the notice?
Fresh certificate will again do it.
Because my lord, on 13th, my lord, your lordship directed him to take first steps on the respondent number 1.
If there is an order, I'll take this. It will go as paid for by learned counsel for the parties. Let this matter be listed again on 10/5/2023 as a fixed time. In the meantime, the applicant's counsel may take first steps. If so advised. Yes.
Regarding.
I can move 49 to 52, my lord.
Can it be taken up after 2 weeks, my lord?
2 weeks.
After 2 weeks. Most probably.
Obliged.